because there's a lot of people. I mean, I've never seen this kind of response in a hearing to have folks make a request to speak, okay? So one of the ground rules that we are going to set for today, I don't care if you use the name of an attorney, a therapist, a psychologist, whoever in the psychiatric community, or even the name of a judge. I don't care. What I do care about, I do not want to hear a co-parent's name that is not here, or an ex-spouse's name that's not here, unless they arrive here and you're working together. We can already see in the media, certain agencies want to spin this to make all of you out to be malcontents and individuals who are just outraged because you didn't win in court. Nothing could be further from the truth. This is about the conduct in the family courts and family court orders. So, with that in mind, please keep your remarks, your testimony narrow in scope to just that. This is a legislative body. Our objective here is to gather information that could lead to meaningful public policy changes in the form of new law or for us to eliminate bad law. I'm seeing a whole lot of north-south nods. So with that, we are going to start with the first up, Jennifer Michelson, Deputy Director of the Arizona Board of Psychiatric Examiners. Jennifer, if you would. And if you would, because this is being recorded and broadcast, get that microphone as close to your mouth as you can. I'm sure that it's been disinfected somehow. Our pages take really good care of the building. If you would please give your name, who you represent, and you have 10 minutes.
Good morning, committee members. I am Jennifer Michelson, the Deputy Director for the Arizona State Board of Psychologist Examiners. Can everyone hear me okay?
Yes.
Thank you for letting me know. I appreciate the opportunity to be here today. It's my understanding the committee had requested a brief overview of this agency. So I'll provide an overview of that and the board's established claims policy that is codified under Arizona Revised Statutes 32-2081. I do just want to know before I get started, I do have two of our current psychologist board members present here today, Drs. Diana Medina and Dr. Joseph Stewart as well, who are prepared to answer questions as well. So the mission of the board is to protect the public by licensing only those who meet the statutory qualifications, by conducting investigations and adjudicating complaints that allege unprofessional conduct, by taking corrective or disciplinary action against licensees when the investigation finds that a statute was violated. The board was established in 1965 to regulate the profession of psychology and has investigated allegations of misconduct on the part of psychologists specifically for approximately 60 years now. In 2010, the board began regulating a second profession, behavior analysts. Currently, there are approximately 2,200 licensed psychologists in Arizona with an active license and approximately 1,300 licensed behavior analysts as well. In terms of the board and staff composition, the board is comprised of 10 members, 5 who are licensed psychologists, 3 are public members, and 2 are licensed behavior analysts. The board members are appointed by the governor and confirmed by the Arizona State Senate. Since at least 2019, the board has had anywhere from 1 to 3 vacancies at a given time. There are a total of 5 board staff members, 4 who are full-time and 1 who is part-time. Board staff consists of the executive director, the deputy director, me, along with 2 licensing specialists and a project specialist. The current board staff are not licensed psychologists or behavior analysts. All decisions relative to a complaint decision or licensure applications, as an example, are made by the board at scheduled public meetings. The board meetings are held approximately monthly, and the board does also have several subcommittees that are defined in statute. That includes our application review committee, the Committee on Behavior Analysts, and the Complaint Screening Committee, which reviews psychologist applications. Relative to the issue at hand in terms of court-appointed psychologists, from 2009 to 2015, a party to a case who wished to have a grievance considered against a psychologist who provided court-ordered services was required by statute to first submit their grievance to the presiding judge, who would render a decision whether merit existed for the matter to be forwarded to the board. In that 6-year period, only one grievance against psychologists was forwarded to the board. In response to parent advocacy efforts calling to remove the judicial screening step for review of grievances concerning court-appointed psychologists in particular, former Arizona Senator Steve Smith sponsored a bill that was enacted in 2015 establishing the board's current claim process. So this has been in operation for over a decade now, which I will address next. So this statute that was established in 2015 for the claims process specifically states a claim of unprofessional conduct against a psychologist arising out of court-ordered services shall be independently reviewed by 3 members of the board, including a public member. Each of the 3 board members who are reviewing the claim shall independently provide the board's executive director a recommendation indicating whether the member believes there is merit to open an investigation. If one or more of the board members who are reviewing the claim determine that there is merit to open an investigation as a complaint, an investigation shall be opened and follow the complaint process that is established in our statutes. Claims are not exclusive to a family court matter, as the statute applies to all types of court-ordered services. So, as an example, the board also receives claims against psychologists when they provided services in a criminal case, such as providing a court-ordered competency evaluation of a defendant. They may also provide other court-ordered services for civil matters involving torts or something such as a guardianship case. So the statute that was created does not grant the board any authority to remove a psychologist from a particular court case or overturn any opinions or decisions made by the psychologist or influence a court of law or judge to disregard that opinion. The board's authority is also limited to determining in the course of providing services to the court whether a psychologist committed an act of unprofessional conduct. The psychologist is not notified of the claim that is being reviewed, nor are they made aware of the claimant's identity at this stage. And my understanding is that when this statute was created, the purpose behind this was to ensure that court-ordered services were not interrupted. As oftentimes the psychologist was actively providing services when the grievance was filed. If a claim does become a complaint, at that point of time, the psychologist is notified and required to submit a response. And they are afforded due process rights throughout the complaint adjudication process. This next slide just basically demonstrates that the claims process and statute is explained in detail on our website, and also when they submit their grievance through the portal. Board members have been supplied with the board's policy and procedures that articulate how claims are reviewed, processed and prepared by staff, and are subsequently reviewed by the assigned board member. The claims are reviewed by these board members independently. It is somewhat of a detailed process, so I will not get into it today, but the next slide provides an overview of the claims workflow. The lighter blue boxes that you see on the left side illustrate the progression of a claims receipt, staff's processing and information gathering efforts, the board member independent review, and that claims found by board reviewers to have merit transition to complaints. Psychologist complaints are reviewed by the board's complaint screening committee, which is comprised of 3 board members. It's my understanding this committee was established in statute back in 2004. The statute for this committee states that they may take either of the following actions. They can dismiss the complaint if the committee determines that there is no evidence of a violation, or refer the complaint to the full board for further review and action at a later date. In terms of claims and complaint data, the green line that you see on there represents the number of claims submitted by the board by fiscal year from 2019 to 2024. Some of the claims in this data pertain to court-ordered services unrelated to a family court matter. This is just encompassing all claims that we have received and complaints as well. The average number of claims received from 2019 to 2024 is approximately 9 per year. So this data represents about 1 claim received per month or slightly less. This data indicates that about 40% of the claims during this time period were determined by the board to be open as complaints for further investigation. By comparison, the board receives on average approximately 4 times as many complaints as claims. So this does conclude my presentation. I hope this information is helpful for the committee. If there's any questions, one of our psychologist board members, Dr. Medina, would like to make a brief statement if that's okay.
Okay. Actually, I have a couple questions for you first. So on your graph, if you can roll back, of the complaints that you receive, are you able to tell this panel whether is there a cluster of repeat offenders? I guess that's the kindest way to ask it. Do you have, are these complaints across multiple people? Or does there seem to be complaints that come, 2 or 3 of those 9 come to a person?
My understanding from the data is it involves all types of psychologists that perform many different aspects of practice. So in terms of the claims, and Dr. Stewart and Medina can speak to this, it's my understanding a very small amount of psychologists do this type of work, so there would be a higher concentration of claims against a few professionals for claims. But complaints, I would say it's very broad.
Okay. Well, if you can follow up with information to my office that we can include in our report of these proceedings.
Absolutely.
I'd like to know if there's a concentration of complaints around 1, 2, 3, 4 people over the last several years. The other question I have for you is, I spoke with the director in a pre-briefing about this meeting, and I understand she's on vacation. Is that correct?
That is correct, Mr. Chair.
I would like to obtain the content of those complaints, and I'm fine with the names being redacted. I'm interested in knowing what are the commonalities across all complaints. And while I have heard that there's an opinion within your agency that you don't have to furnish that, I would say under Arizona revised statute you do.
I will certainly research that, Mr. Chair, and inform the executive director of the request.
Thank you. Members, any questions for Jennifer?
Mr. Chair?
Representative Fink?
And I don't know how you do this, but anyway, how does the board evaluate whether a psychologist has appropriately considered the best interest of a child in visitation or custody recommendations?
I would defer to one of my psychologist board members to answer that question, perhaps Dr. Stewart, because they are the individuals that review this and make decisions relative to that, not myself as a staff member. So if the committee would mind, Dr. Stewart.
That's fine. If you would, sir, please give your full name and who you represent. And like I said, there's actually a switch on that table.
The investigation.
Raise the table so that you can get the microphone closer to your mouth. Thank you.
Good morning. I'm Joe Stewart. I'm a psychologist. I'm a psychologist member of the Board of Psychologist Examiners.
Okay,
Okay, thank you.
do you want me to
Representative Fink.
my question here. So how does the board evaluate whether a psychologist has appropriately recommended the best interest of the child in making custody or visitation recommendations?
Thank you for the question, Representative Fink, and Chair and Co-Chair. That's usually spelled out in the order of the court. So the psychologist is limited to what the judge directs the psychologist to look at. And so the best interest of the child is, I would like to say, universally understood, Any specificity to that is through the court order, the language in the order.
Okay.
Representative Keshel.
Yeah, Mr. Chair, thank you. Doctor, what was your last name again? Stewart, thank you. So some of what my understanding is, and I understand what you're saying that it's in a court order, but some of what I'm understanding is some of these psychologists are actually kind of superseding the judge in some of these and actually making recommendations or orders that they shouldn't be. Is that something that your board would potentially, if someone were to make a claim on that you would consider a serious enough offense to turn into a complaint? I guess my question is, what are you looking for as a board for taking those claims and then pushing them to the next level of a complaint?
Certainly, if there's as I understand it, Representative Kessel, you're saying that the psychologist is placing themselves in a situation of superseding the judge and doing what they want to in spite of any specific order. Is that correct?
To that point, sir, I think what Representative Keshel was talking about is the claim of quasi-judicial authority, where essentially the mental health care professional is given extremely broad latitude, I mean, beyond what the judge may be aware of. I believe that's what you were referring to, yeah.
Well, certainly it's... as a forensic psychologist, I no longer do any kind of family law or child custody. I don't do criminal cases. But if they're superseding, going beyond their scope of order, then that should be foundations for a complaint. As to whether that would proceed to the next level, I don't know without specific documents to look at.
To that point, I'm not going to ask you to go down any hypothetical rabbit holes.
Thank you. And I certainly appreciate that.
I do
They scare me this early.
They should. They get very dark down there.
I do have somewhat of a to that point. So your board makeup, because you just insinuated that you were potentially affiliated with the family court type situation. When the board members are chosen for the board, do they take into account, because it was said that they cover, it may be different types of court cases, not just family court. Is there like a specific thing that you, I guess, formula that you have that you're going to have two from the family court, one from the, do you know what I mean, with who you pick for the board? Are they all from the same kind of background? Do you get a difference in background?
Let me see if I can respond to that, Representative Kessel. There are only 5 psychologist members on the board, and so on the complaint screening committee, I am one of those. So I look at whatever the complaint is. We have statutory guidelines to follow, what the statutes are. We see if the psychologist has violated any of those. We also have the American Psychological Association Code of Ethics that we look at. Is much a longer list, and see if the psychologist has violated one of those. So that's what I'm looking at. I don't know that I differentiate whether it came from a commissioner or a superior court judge or a criminal case or family law. It's more in terms of what the complaint is, how it's worded, comparison to the Code of Ethics and the laws of the state of Arizona.
Thank you, Doctor. I'm glad that you brought up the Code of Ethics and the canons of conduct. So according to the American Psychological Association, the ethical principles of psychologists in the Code of Conduct, they do indeed refer to do no harm to the child.
Correct.
What we heard in the last committee meeting, and I wouldn't expect you to know this, and the fact that you're not in the family court program now, I get it. But if there is a complaint that comes from a parent that specifically references harm to the child. Because this is sounding very much so far like it's about two adults, and the minor seems to be getting lost in the whole conversation.
Agreed.
Is that a kind of a complaint? And quite frankly, that's the reason this committee was drawn together. Because it's become abundantly clear that the civil rights of children are being abrogated, perhaps by the court itself. Now, okay, ladies and gentlemen, okay, I guess I need to cover this again. Just a minute, Doctor. I need to cover this again. We cannot have any outbursts like that. No moans, groans, or clapping, okay? There is a decorum here in the Senate. We need to make sure that this is, we're gathering information here. This is not a court of public opinion. That is outside in the plaza, okay? Please, if we have an outbreak like that, I don't want to have to excuse people from the room. This hearing is for you, okay? So let's make sure that we give the individual who is at the podium due respect, and let's not have an outburst like that again, okay? If you would, sir, could you, I'm going to restate the question because it totally broke my train of thought. If there is a parental complaint that is made to the Board of Psychiatric Examiners that there has been harm done to a child, I presume that that is something that the board would take very seriously.
Absolutely.
Okay.
And it's the Board of Psychologists Examiners, and if there is a complaint like that filed, we cannot go on hearsay, we cannot go on third-party information, so we look for original documents of such neglect or abuse or intimidation or threat of intimidation or absence of their legal rights. And so hopefully the complainant will provide that type of information. That's what we can act on. We cannot act on one parent accusing the other parent. As you so said this morning, you don't want to hear about a parent who's not in the room. And so we cannot act on information where there's inadequate documentation to support the claim.
And for the clarity, Doctor, I'm not talking about parent against parent complaints. I'm talking about the complaint of a parent to a mental health care provider.
Yes, sir.
So, for example, I'll just throw a hypothetical out there. I'm not going to ask you to answer it, but you have a parent who is in a session with the child, and something in that session occurs where the parent observes a behavior by the provider and takes note of that, and then subsequently files a complaint about the interaction with the provider. I understand that some of these interactions can be hostile. This is a really sensitive area of life. I get that. But I guess where I'm going with this question is, this is about an interaction with the parent and the provider, or the child and the provider. Do you also take into account first-person testimony from the child themselves, the minor themselves?
We do not. We don't have a child advocate on staff that can sit with the child to take that type of information. I think that would be an excellent recommendation to your group and to the House to undertake and put that into, to codify that, where that would be a possibility. It seems like it would require a child advocate to be there, and someone with the board staff would have to interview the child perhaps and gather that information. Is that approximating an answer to your question?
You're right over the target, sir. I've long wondered why, in cases that drag on for more than a few weeks, why a guardian ad litem or a similar child advocate isn't appointed by the court to see to it that that child's civil rights are protected.
If I may, I think that I have seen that done frequently. We have guardian ad litems in criminal cases and also in guardianship cases all the time. And I also remember back when I was doing child custody work many years ago, that guardian ad litem would be appointed.
So
That depends on the court.
I'm sorry.
That depends on the court.
Mr. Chair?
Just let me finish real quick. So in your professional opinion, I think I heard you say that you believe that that would be a good addition, perhaps, to statutory assignments in order to make sure that the civil rights of the child are also represented in the courtroom. Is that an approximation of your answer?
I think a guardian ad litem being appointed could fulfill that role for protection of the child would be a wonderful idea myself.
All right.
I don't know why it's not done more often, perhaps.
That is a head scratcher. Okay, Representative Fink.
Yeah, I apologize, Mr. Stewart. And along with that fact, because I've many instances where I've had people come to me where the child is with the psychologist and there has been, what's documented, you said you look at the documents, what the document is not what the child reports. So therefore, that happens quite a bit. And so therefore, when you do your due diligence, that is not documented in those reports that you receive. So I'm hoping that the guardian ad litem would that take care of it, or being able to even have parents in attendance, or what would be other suggestions in regards to helping that out?
I think the guardian ad litem, Representative Fink, would be a good approach to that. You still have the psychologist in the room with the child by themselves, is that the indication? So you still have that situation. So what the child reports to one parent, I think we all know that is not necessarily the thing that the child reports to another parent. And so hopefully the guardian ad litem would be able to get a more neutral environment and get an answer approximating accuracy.
Mm-hmm. Right.
I do have another question, or did you want to ask another one?
One more. Let's
Go for it.
No, go ahead. One more question for this gentleman.
Okay. One thing is, just generally speaking, would it violate the ethical canons? We talked about, the ethical standards for psychologists to reject, ignore, or fail to acknowledge official reports from other court-appointed professionals, such as social workers or investigators, whose findings might contradict the psychologist's conclusions?
Yeah. Let's see if I understand the question, Representative Fink. Should the psychologist examiner consider reports by other professionals, social workers, licensed professional counselors, substance abuse counselors, marriage and family therapists, that contradict the findings of the psychologist?
Correct.
Absolutely. Absolutely. In a fair hearing of the facts, I consider contradictory reports all the time in criminal cases, and I would think that would be most appropriate in juvenile cases.
Okay. Thank you.
This is probably more a question for, I'm sorry, members, any other questions for the doctor? No? Okay. This is probably more a question for Jennifer. So, does your board ever work with the Arizona Department of Child Services while reviewing complaints? I mean, is there a coordination of effort, or do you do what you do and they do what they do, and there the two shall meet?
Typically a very separate process. I can think vaguely of some cases of their coordination to determine what their investigation has found, but it has been difficult to obtain documentation from them.
Okay. What about the Arizona Attorney General's office?
In what capacity, Mr. Chair? Our board is represented by an assistant attorney general.
Okay, well, I understand they represent you, but I guess I'm probably talking more about a referral. for either criminal or civil action?
The board has made referrals in the past to the Attorney General's office. My understanding, I believe it has been to the criminal division with respect to unlicensed individuals either claiming to be a psychologist or practicing unlawfully. That is my recollection, I believe.
What about Child and Family Protection Division at the Attorney General's office while working on complaints about providers specifically?
Yeah.
With
I guess in a way you've already answered that question. I'm just trying to get clarity around the process that your board has for, at what point do you involve the AG's office? Is it after you have concluded your review and you've now made a recommendation, or do you call them in early at the first notice of something that could be a referral?
So any determinations are made by the board through the adjudication of a matter. So once the matter is resolved, then typically they would make a separate motion for any kind of referral.
Okay. What about the Committee on Family Court? You coordinate with them at all?
We've had no contact with them.
Really? That seems surprising. Representative Kessler?
Jennifer, thank you, Mr. Chair. So, as far as these psychologists, regardless of what, which court they might be, working with, who is responsible for, I guess, training for them to make sure that they're not acting out of their scope of practice? Would that be you, the board, or would that be the court that they're part of? And yeah, because I'm wondering where the oversight is for what they're actually doing.
Representative Keschel, thank you for the question. I would defer to Dr. Stewart in terms of the training for their scope of practice for that specifically.
Thank you, Representative. Continuing education hours are required for license renewal. So many has to be done every 2 years. And so within that, the scope would be ethics as well. So that would be included there. I think there are 40 hours every 2 years for that. Now, I know for criminal court, I'm sorry, I know this is another issue, but the state Supreme Court holds training every 18 months for psychologists in the criminal aspect. So being a witness, the psychiatrists and psychologists that do the competency evaluations, we meet every 18 months to go through the Supreme Court training, so 2.5 day training. And then that list of people that are in attendance goes to the various divisions of the Superior Court. In terms of family court, I don't know how that, if the family court has any such training requirements or not.
Real quick to that point, I guess. So some of my concerns then, if you found out that a psychologist was acting beyond their scope of practice, would that be enough to take a claim to a complaint, I guess, to that level?
Absolutely.
Okay.
Outside of scope of practice, if they were, for instance, talking about prescribing medication in this state, there are 7 states that allow psychologists to prescribe medication. Arizona is not one of them. So if that was the nature of the misbehavior, if you will, then that would certainly be worthy of a complaint, and that would push it on us.
Okay. And one more, Mr. Chair. Have you ever, when there's an active, actually, claim or complaint, not a claim, on an individual, a psychologist, are you open as one of your possible avenues to recommending that that person possibly be removed from a case at that point? Or
we have no such power to do that.
Okay. Again, I don't know if this is for you, Doctor, or for you, Jennifer. To obtain licensure with the board, do you require somebody to complete education in the, quote, social basis of behavior which may include social psychology, group process, cultural diversity, and organizational and systems theory.
Mr. Chair, I'm going to request that Dr. Diana Medina address this as she has expertise in this area in terms of qualifications for licensure.
All right, ma'am, if you would, please give your name for the record. Yeah.
Sorry.
That switch comes in handy, doesn't it? And please get as close to the microphone as you possibly can.
Okay.
Good morning. I'm Diana Medina. I am a licensed psychologist and vice chair of the board. So in terms of education, absolutely, there are rigorous standards for education. Of course, social psychology is one of them, clinical psychology, human development. There are certain areas that we look at. Most of the programs that provide that education, when someone is pursuing a doctoral degree in psychology, have what is accreditation from the American Psychological Association, and they ensure that there is training in each one of very specific areas. Furthermore, once folks graduate, they need to have a certain number of hours of training. And when someone wants to specialize, so for example, neuropsychology or forensic psychology, they do so under the supervision of a neuropsychologist or forensic psychologist for, typically it's a couple of years until they are able to call themselves and present themselves as forensic psychologists or neuropsychologists or having a specific specialty.
Okay. I guess more specifically, the question is around DEI. Is that something that's required of potential licensees to go through a curriculum that's DEI based?
It is my understanding that as of this year, that requirement was revised, but it was in terms of having competency, cultural awareness, having so a certain level of competency in different cultural backgrounds.
Okay. Jennifer, if you wouldn't mind, I'd like to know what the requirements are. I mean, I don't expect you to answer this question now, but if you would forward that information on to me, I'd appreciate it. Members, any other questions for Jennifer or the doctors?
I think I have this question would probably be for the doctors, Mr. Chair. So there's been a big topic here in Arizona has been the parent-child reunification process. Yeah. You know, where they're insisting that this is decreasing the time, 1 to 2 weeks to get things all fixed and better. I guess, what is the board's take on that? I mean, some of what I have heard regarding that program, that it's costing parents upwards of $15,000. Is there really evidence that it works? Because I have some major concerns about that. So I guess, what is the board's take on that process and some of the maybe negative things that I'm hearing that coincide with that?
To my experience, and Jennifer, you can correct me, we don't look at that specifically because that is with the family, what the family court system and what that training entails to function in that capacity.
Would you, Mr. Chair, one follow-up, would you be open to maybe looking more into that and potentially, I don't know how you could possibly step in, but since you are a board of psychologists, it might help to have some good raw data to give to the courts to potentially help give some good, solid facts on that type of situation, if it's really helping these kiddos or not.
Sure. Absolutely. There is also, psychologists are one of the professionals that do that type of work. There are other professionals that are licensed by other boards that also do that type of work, but we can most certainly look at what pertains to our board.
Okay. I'd like to ask a hypothetical, if you don't mind, and I'll try to keep it high on the rabbit hole. All right. When you have an individual within an office who is not enrolled to become a therapist, enrolled in school, or who is not a graduate of a school, is it appropriate for that individual to be assigned as a so-called therapist under the direction of a psychologist or psychiatrist, a PhD level mentor, if you will?
Yes, so that person needs to be working under the supervision of a licensed psychologist, and as a supervisor, the supervisor has full clinical responsibility over the work that is done by their supervisee.
Okay.
So if I am supervising someone who completed their doctoral degree, they're accruing hours maybe after, a postdoc, let's say, or works under my license, it is my responsibility to provide the supervision and guidance so that their work is reflective of our ethical guidelines and our statutes.
Okay, I get that piece, but that kind of avoided answering the question that I asked, and I don't think you
apologize.
intended to do that. If an individual who is working under the direction of a PhD clinician either does not have their education completed or is not enrolled in education at all, is that a violation of the Code of Ethics? Because you've got an individual who they're not even in school.
Right. So I understand that part. Have they completed school prior? Is it they're not? So if they have not completed a degree that would render them, I would say, right, in mental health, and they're not accruing hours, right? Because that's how we bring up the next generation, right? We teach. And so they need to be enrolled in an educational program. Then I'm not really sure how that would.
Okay, so just to recap, they're not enrolled, nor have they graduated. Meaning they didn't go through all the way and graduate, and now they're doing their practical, their in-service, whatever your profession calls it. As a paramedic, mine was a practicum. I had to do so many hours in the emergency room, so many hours in cardiac, so in order to qualify for my licensure.
Right.
I wasn't enrolled because I had graduated. So my question is, if an individual is acting in that trusted counselor, clinician capacity, but is not enrolled in school to do that, nor have they graduated from a program, is that a violation of the Code of Ethics? I'm sorry, I guess I should finish the question. By the PhD level clinician who they're supposedly working under.
Right. So I think that would fall probably under competence. I think it would be on the burden of the psychologist to show how this person has acquired competence. And I'll give you a hypothetical, if you will. Let's say someone has not a doctoral degree, but they had studied and obtained a master level degree. Maybe they started their doctoral training, but for whatever reason they did not finish, but have many years of experience and received training. It would be on the psychologist, on the licensed psychologist, burden to show that this person has competence. It does not fall into the typical categories of a practicum student getting hours to graduate, nor it falls under the internship, which is also required for graduation, nor does it sound like it would fall under the postdoctoral side of things, which is the hours that you accrue postdoctorally to obtain that, let's say, classification, that specialty.
Okay.
So,
Members, any further questions?
Mr. Chair? I know, you looked at me.
One, we got to move on, otherwise we're not going to hear from parents.
Representative Fischel alluded to this, but it was in regards to parent alienation, because oftentimes that's utilized in courts. Do you recognize that as a, quote, diagnosis to be able to warrant a lot of the therapeutic interventions and all of that?
as a formal psychological diagnosis, I do not.
Okay, thank you. I'm done.
Okay, thank you very much. Next up is
Thank you, committee members.
April Elliott and Colleen Concannon. if you would, from the Commission on Judicial Conduct. And, yep, you know where the switch is at? Good.
I have a similar desk.
Okay, if you would, please get as close to the microphone as you can so we can get a good pickup. And give your name for the committee and who you represent.
Good morning, Chair Fincham and Chair Kushel and members of the committee. Can everyone hear me okay?
Yep.
Okay. I'm April Elliott. I'm the Executive Director for the Arizona Commission on Judicial Conduct. Also appearing with me is Colleen Concannon, who is one of our public members. And just by way of background, I've been an attorney for 30 years this year and did family law when I was in private practice. And I previously was a Superior Court judge in Pinal County where I had a family law calendar.
So she's part of the problem.
So let me jump in with, I brought some packets of information because I know my time was going to be limited with additional information regarding the commission. There's one for each member of the committee, and then there's one I believe you can incorporate into the public record for this proceeding. So what is the commission? The commission is actually created by Article 6.1 of the Arizona Constitution. The voters passed that in 1970, and there were some subsequent amendments in 1988. It's an independent state agency that is responsible for investigation of complaints against judges under the Arizona Judicial Branch. This extends to judicial officers at all levels, so from City Court, Justice Court, Superior Court, Court of Appeals, and the Arizona Supreme Court. We do not have jurisdiction over federal judges, tribal judges, or any administrative law judges that work for an executive branch agency, such as administrative law judges that hear unemployment claims or workman comp claims. Likewise, the commission does not have jurisdiction over court employees, attorneys, members of law enforcement, or any other elected officials such as constables or clerks of the court. Judicial conduct commissions exist in every state, and they do play a vital role in promoting public confidence in the judiciary and in preserving the integrity of the judicial process. We are a forum for citizens with complaints against judges. We are not to be confused with the Commission on Judicial Performance Review, JPR, which is a separate entity that reviews the judges' scores on the surveys and then makes the recommendations as to whether or not those judges meet standards for purposes of retention elections. So people conflate us with them, and we are separate. So the Constitution sets forth who are the members of the Commission. There are 6 judicial members who are appointed by the Arizona Supreme Court. There are 2 Court of Appeals members, 2 Superior Court judges, 1 Justice of the Peace, 1 City Court Magistrate. 2 attorney members are appointed by the State Bar's Board of Governors. And there are 3 members that are appointed by the Governor and then confirmed by the Senate. The members are all volunteers. They receive no compensation for their work, but they are entitled to be reimbursed for expenses if travel is involved. And the commission is supported by a small professional staff. The Constitution sets forth that the Arizona Supreme Court promulgates the commission's confidentiality rules.
And would you guys, what was it?
So what can the commission do and what can we not do? So we are limited to investigating allegations of judicial misconduct in violation of the Code of Judicial Conduct, and if warranted, then imposing informal sanctions or recommending the imposition of formal sanctions to the Arizona Supreme Court. The allegations in each complaint are considered on a case-by-case basis in accordance with the Code. So some examples of judicial misconduct include improper demeanor, yelling, rudeness, or using profanity, improper communication, such as ex parte communications, communication with only one side, delay in performing judicial duties, public comment about a pending case, or improper off-the-bench conduct, such as criminal behavior or other things in their private life that might run afoul of the code. What can we not do? We can't change a legal ruling made by any judicial officer or direct a judicial officer to change a ruling. We can't have a judge taken off a case or have the matter assigned or transferred to a new judge. We cannot intervene in a pending matter. and neither the commission members nor staff can provide legal advice. So the commission is primarily concerned with the judge's behavior, not judicial decisions. Comment 3 to Rule 2.2 of the Code states that a good faith error of fact or law does not violate the Code. However, a pattern of legal error or an intentional disregard of the law may constitute misconduct. Any violation of the Code of Judicial Conduct must be proven by clear and convincing evidence. A mistake in a ruling does not automatically mean the judicial officer has engaged in judicial misconduct. Judges are required to exercise their discretion when they make decisions. And even if a judge's decision might be legally or factually incorrect, the ruling is generally considered to be legal error and not ethical misconduct that the commission can address. When a complaint to the commission solely relates to the correctness of a judicial officer's legal decisions, the complainant is seeking the commission to function in the capacity of an appellate court. And correcting legal errors is the role of the appellate courts, not the commission. And by way of example for every person who's sitting in this room who likely says that the judge got it wrong in their case, there's another side that says the judge probably got it right. Those folks are not parties to our process. So for us to step in to make, to correct what we think might be legal errors is not our role. They have an ability to be heard through the appellate process, and that's where those is the better form for those to be resolved. However, we understand that appeals can often be very costly and complicated. There's no charge to file a complaint with us, and it's a fairly easy process. So unfortunately, a lot of folks come to us when they really should be filing an appeal or some sort of other appellate review. One of the things I forgot to mention, but I thought of it when in listening to the prior presenter, one of the things that is prohibited for a judge to do under the code is that a judge is not permitted to conduct an independent investigation. A lot of people misunderstand that. So a judge is limited to the information that is presented to them by the parties. So they have to rely on what's presented to them, including expert testimony. And there was a lot of questions for the last folks that I anticipate there might be similar questions for me, but the wishes of the child are only one of the statutory factors that the court can consider. So just anticipating that. Our complaint process, anyone can file a complaint. We do accept anonymous complaints. There is no charge for filing a complaint. However, the complainant is not considered to be a party to the commission's case. That's set forth in the commission's rules. But they are entitled to receive acknowledgement of the receipt of their complaint, notice of any public hearing, and the written dispositional order regarding the complaint. What becomes public is outcome-driven. In dismissed cases, only the complaint and dispositional order are public after all identifying information is redacted. If the complaint does result in a public sanction, the record is public. Meetings of the commission are not subject to the public meeting laws under ARS Section 38-431.08A3. Had I known we could bring a PowerPoint, I probably would have done that.
That's all right. You brought a stack of trees.
I did. I'm not environmentally conscious today.
That's all right.
A complaint form can be obtained off the Commission's website, which is www.azcourts.gov/AZCJC, or by calling the Commission's office at 602-452-3200 to have a form mailed or emailed to you. The members of the Commission review all the complaints after staff has completed an investigation, and it is the members of the Commission, not staff, that decide what action to take on a complaint. For the last 2 years, the Commission has received in excess of 500 complaints per year. This year, if the numbers hold, we are on track to receive more than 600. The disciplinary counsel position in our office is primarily responsible for the investigation of all complaints. We have one permanently funded disciplinary counsel position. For the last 2 years, the Administrative Office of the Courts has assisted in temporarily funding a second position through grant funds, but there is no guarantee that those grant funds will extend beyond June 30th of 2026. We have submitted a legislative funding request to permanently fund a second position with no success so far. That request is still pending this year. It's a daunting task for only one person to investigate 500 plus complaints. For this fiscal year, basically from July 1st of 2024, and I cut it off at April 30th, 2025, we had received 463 complaints. 103 of those, or approximately 23% of those, related to family law matters. We do not track involvement of behavioral health professionals in family law complaints, such as therapeutic interventionists, court-appointed advisors, parenting coordinators, best interest attorneys, or guardian ad litems, or any psychological or custody evaluators.
Excuse me. I hate to interrupt you, but I've got like a dozen questions that are buzzing around in my head, and I'm going to forget them if I don't.
Go ahead.
You just gave a number for the last 12 months, and I'm sorry, that number was what, 400?
463 basically from July 1st of last year to April 30th of this year.
Okay,
So
how many of those are founded? Or are they all unfounded?
Statistically, I didn't run that specific.
I'd like to know that, and I'm not
I
trying
was
to
just saying-
ask you to make up a number. Just
No,
let me know what
but
that number is.
I can say generally, our dismissal rate hovers between 85 and 90%.
Mr. Chair.
And that is not unique to our commission. One of the items that is contained in the packet that I gave you is information from the Center for Judicial Ethics at the National Center for State Courts that discusses why commissions nationwide disregard a large percentage of complaints. Generally, the main reason is because at their core, the majority of the complaints are disagreements with legal rulings. And that's beyond what we're able to address.
Mr. Chair, I have a number for 2024. Out of 485, three resulted in reprimands.
I think that's inaccurate because the way that we post to our website is by the year of the complaint. So there were some 2023 cases that were resolved in 2024. So the annual report that is in the materials that you have breaks it down by what was technically resolved in 2024.
Okay,
Well,
we'll review the
Yeah,
complaint.
and to that point, so you talked a lot about the Constitution. I love the Constitution. We're limited at the federal level. If Congress, if there are issues with the judge, Congress can investigate that judge. Here, we don't have the power to do that, so we rely on you via the Constitution to help in some of those manners. So I'm wondering, I understand what you're saying because I will tell you right now, a lot of what I've heard is the law is being broken from the bench. And everybody tells these families, oh, we'll just appeal it. But the success rate of that is very low too. So these families' kids are left in the hands of judges that you're hoping will follow the law.
Well,
And so I'm wondering what responsibilities, we need to give to you constitutionally so we can actually get somewhere.
And to that point, I find it a rather flippant response. Well, we've got the appellate process. These are people who are being bankrupted by court orders. Now they have to pay to go back to court again. I have a bit of a problem with that. But
I understand your
know you're
concern, but
trying to-
understand what our limits are currently at.
No, I understand.
And appellate judges go through a vetting process. They're vetted by a committee. They're appointed by the governor. They stand for retention.
With all due
The
respect,
public
ma'am, I
doesn't
don't
have
wanna
a vote
I
on
don't
who
wanna
serves
make
on
this
the.
about the appellate court.
I'm just
okay?
saying the public doesn't have a vote with who sits on the commission. So I'm not really sure it's fair to shift that responsibility to unelected individuals.
Okay.
That's
Fair
my
enough.
point.
Let's try and finish up with your presentation within the next 5 minutes, because I know there's a whole bunch of questions, and we still have to get to parents.
Okay. So in terms of public outreach, the public can bring complaints to us regarding family law judges, but just understand that it is not the commission's role to re-weigh the evidence or redetermine witness credibility and determine whether or not the judge's decision on custody, parenting time, support, or the employment of an expert was appropriate. We received many complaints. Wait, just back off from that. So 2 years ago, we did begin a Coffee with the Commission event in which we invited members of the House and Senate Judiciary Committees to come and have coffee with the Commission and learn more about our process and ask questions of the members. That was to allow the people's representatives the ability to learn more about our organization and what we can or cannot do. Unfortunately, in a world of limited resources, we do not have the funds to do more robust public outreach. We have discussed potentially doing a video that we can put on our website regarding our role, as we know that some folks learn easier via video than reading the information. So that is in the works, but in terms of more travel to do more outreach, because a lot of members of the public really do not know that we exist, we just simply do not have the funding to do that. And with that, I would open it up to questions for either Ms. Concan or I.
All right, great. I have a couple questions for you.
Sure.
So, hypothetical, would it be improper for a judge to threaten a parent or a minor in court or outside of court through their attorney, that if they were to come to this committee and testify, that they would be held in contempt?
I can't opine because that's the member's purview. I'm not sure, and I would also probably want to know more context in terms of that. But maybe Ms. Concan would be better to answer that.
Please give your name and who you represent for the record.
Colleen Concan, I'm a public member of the Arizona Commission on Judicial Conduct. To answer your question, that would absolutely be investigated. And just so you understand what the investigation involves, it involves talking to every party that we can find involved in it. We make the effort to go out there and see whoever can talk to us, and especially people who are afraid of losing their jobs. We're very careful with that because that's something we don't want to see happen, and all we really are trying to get to is the truth. All commission members review all cases. Sometimes people don't realize how much time we are putting into this, but it's hundreds and hundreds of hours a year to make sure that we have thoroughly investigated everything we can. If we can't find the information, then yes, sometimes injustice is done. But we're certainly trying to get that every time we can.
I appreciate that. Is your position a paid position or volunteer, ma'am?
No, I'm a volunteer.
Okay. Now, I'd like to move on to the question of quasi-judicial immunity. I think I heard you say that your responsibility is only to review the actions of judges and complaints concerning judges. Is that correct?
That is correct. We don't have jurisdiction over anyone else.
Then why on earth is quasi-judicial immunity offered to non-judges who appear to be outside of the scope of your examination?
That I cannot answer. I think that would be a question for the folks that conferred it.
Okay.
I have a personal theory in that they wanted some of this, they wanted the quasi-judicial immunity much like the judges have, so that there's a layer of independence that these individuals cannot feel threatened or intimidated by what others do.
Okay, but ma'am, that doesn't make sense to me.
Yeah.
Again, I didn't enact that law, so that's probably a better question.
Please let the chair finish.
I'm sorry.
If an individual is protected by quasi-judicial autonomy, who on earth is holding them accountable? Acting in the capacity, essentially, as a judge to make certain orders happen.
No one.
I can't answer that.
Because there's
That's a fair
no
enough
one.
answer, thank you. Finally, my last question is, if it's revealed in court that there's been a crime against a child, specifically child abuse, whether physical, mental, or emotional, does the court have a duty to respond and report that to law enforcement? I mean, is the court, is the judge themselves, do they have a duty to notify?
I don't want to misspeak. I don't believe judges are considered mandated reporters under Arizona law. I'm not 100% certain on that.
Thank you for your honesty.
I actually do have a different question. There is a judicial ethics opinion that discusses a judge's duty to report illegal conduct that is revealed during court proceedings. It's an ethics opinion. And it essentially basically says it's within a judge's discretion. However, the opinion goes on to talk about that for every person who might testify that perhaps they cheated on their taxes or, got money under the table that wasn't declared, things of that nature, that, those are somewhat discretionary, but if it's more serious, then the opinion talks about then the judge should heavily weigh whether or not it could be reported. One of the factors to consider is it reported by anyone else? Judges will oftentimes make referrals to the Department of, I wanted to say CPS because that was my day, but the Department of Child Services to investigate when there are allegations like this, because the court isn't really equipped to be a criminal investigator, but they can make referrals.
No, thank you. I absolutely understand that. And I guess my point in this question is, if the court becomes aware of child abuse, whether physical, mental, or psychological, does the judge, like anybody else, have a responsibility to report that to law enforcement? I'm talking about there's evidence. There's first-party testimony from the minor.
Again, I would say that the ethics opinion states it's within the discretion of the judge, but as far as I know, I don't believe judges are mandated reporters.
All right. Thank you. If we need to research that, please. All right. All right, members, any other questions? All right. Thank you very much. I appreciate your time and your testimony. Okay, next up, Mr. Jax Atwell. Jax, are you here? Raise your hand. Oh, there you are. All right. And I'm at the risk of trying to limit your time, please, economy of words is great because we are already at quarter after 10 and we're just getting to parents. So I know you probably have got a lot to tell us, but please proceed, give your name and whether you're representing yourself or somebody else. And you got 10 minutes and then we'll probably open it up for questions. All right?
Mr. Chairman, members of the committee, my name is Jackson Atwell.
Jax, if you would, please get as close as you can to the microphone. Thank you.
How's that? Mr. Chairman, members of the committee, my name is Jackson Atwell. Thank you for allowing me to speak today. I commend the committee for stepping beyond political routines to listen to the voices of like-minded voices to represent not just ourselves, but countless parents who could not be here, those overwhelmed by the system, and families who have suffered loss, despair, and injustice. I stand before you only by the grace and strength of God. My time is short, so I'll represent the facts directly, reference exhibits, so you can see the evidence for yourself. My perspective is unique as a former police officer in 2 states, and as a licensed private investigator in 2 states for the last 15 years. My wife and I have gathered evidence in ways few others can. After 6 years of fighting for a right to be a father, I'm now facing bankruptcy, crushed from all sides, with no resources left to defend myself and fight for the well-being of my son. The only thing I have left is the truth. With nothing to lose, I am here to expose the corruption I have witnessed. Family law cases in Arizona are rarely about the children. My minor child is hardly mentioned, if ever. Yet there are mountains of casework against me in the shape you'd expect in a high-profile criminal case. Being a parent is one of the most important titles you can hold in life. I'm honored to have and raise 2 amazing young men and help raise an amazing bonus daughter and bonus son. They're all striving and thriving in life. Yet when it comes to my youngest child, I'm bankrupted, harassed, and beaten down because of what? All because I chose not to be in a relationship with a mother, but still wanted to be an active parent in his life. This is something that any family court should strive to support rather than strip away. Please understand that in my limited time here, I'm representing just the tip of the iceberg. systemic abuse, and financial devastation. Initially, I came prepared to share the mental and physical abuse my family and I have endured, and abuse-filled lies, cherry-picked information, official documents being disregarded, and violations of Rule 69 and established legal timeframes. While my case has been horrific, it may not be the worst on record. My experience as a private investigator for similar cases has shown me that others face far worse injustices. With that perspective, I want to focus on the financial impacts that the system, for example, pediatricians in contact with opposing counsel and in charges for medical records. I don't know if you guys have copies. They're supposed to get copies of exhibits.
We don't, but you'll be able to give it to Zach here once you're done.
All right, thank you. $500 cash only charges being mandated by child advocacy appointments, the CAA. Judge orders counseling from an unlicensed marriage counselor, counseling fees of $165 an hour for a situation no marriage ever existed, causing distress with my spouse.
Excuse me, Jack, was any of this covered by insurance?
No.
Okay, so let me get this straight. You've got individuals who purport to be therapists, who purport to be licensed therapists,
Correct.
and they don't accept insurance.
I don't know. I mean, I don't have insurance, so I don't know if they accept it or not. It wasn't ever portrayed to me. We were given one person to go to and no options to go to anyone else.
Okay, all right, please proceed.
Opposing party inflates income deductions on every affidavit of financial information, which is, it'd be obvious when you look at it. I'm sorry, I don't have them copies of it. Contempt of court findings and maximum fines with interest when father cannot pay, pushing him towards financial ruin or bankruptcy, though bankruptcy itself is unaffordable without savings for it. Overinflated rulings being punished for accruing interest at the maximum legal rate. Credit being manipulated in court to inflate child support obligations. Mother gets credit for these items if father is found in contempt by judicial officials for not paying half, double dipping. One of the big things I'm here to talk about today is the state tuition office and the state tuition office representative organization, IBE, which is a Catholic organization that gives scholarships. Mother lied under oath paying that she paid the tuition.
Okay, hold on a second. I asked everybody, please do not make accusations about the opposite side of the argument. This is about the court.
Understood.
This is about lawyers, and this is about therapists. So let's move past, because we're not going to relitigate that part of it.
Understood, Mr. Chairman. Let me rephrase.
All right.
The opposing party was giving cash value for the scholarships to the state tuition office.
And that was presented to the court?
Correct.
All right.
I was denied legal rights to a document in a recorded call with the IBE attorney Robert Fee. He's the actual attorney for the IBE state tuition office organization. My email seeking clarification with Robert Fee is also included here. Where I'm trying to clarify what I'm getting.
person, so I was wishing I had those documents to look at while you were talking. But you're saying that basically one party in this situation was benefiting financially and the other party, the opposite was happening. They were being, I mean, so to speak, ruined financially. Is that kind of the sum of what you were saying?
100%.
Why? What do you think the purpose is for that?
It's unknown. I have striven for the last 6 years to try to uncover that. I've tried to uncover the why isn't always going to happen. A lot of parties involved, a lot of things I didn't get to go into here today. Other things that were done in the court order that I suppose I would do, and so then you have all these other departments and things going on that are all benefiting from the court system.
Okay, so to that point, I have one follow-up. Do you have, because it seems like you've got the, some evidence, so to speak. Do you have any evidence of judges benefiting from one party benefiting?
As far as being able to directly correlate, where I've been able to prove, they're getting $1 for doing this.
Yeah,
No.
okay.
No.
All right, members, any other questions? All right, thank you very much. I appreciate it, Jack. If you would,
Campaigning.
just hand
It's
these
for
those
campaign
documents to
finance.
this gentleman right here. All right. Next up, Robert Del Garbino. Robert, you have 10 minutes. If you would, please give your name. And if you're representing yourself or someone else, give us an idea who you're representing. And get as close to the microphone as you possibly can.
Good morning, Committee Chair, Senator Fincham, and your esteemed colleagues. I have a document. Zach, have you distributed this to all the members?
Yeah.
All right. This is a 14-minute page. I represent not only myself, my family, but hundreds of other families.
Yeah.
What I'm going to tell you is how the court system has been subverted and abused by psychologists. And I hope you grant me the 14 or 15 minutes. Allow me to
Talk fast.
Yes, sir. Allow me to get through it and then ask questions, please. We're here to expose the despicable acts and deeply rooted corruption in family court system perpetrated by some reprobates over the last 20 years. Scoundrels that have leveraged flaws and created loopholes in our family court system for personal gain at the expense of our children. There are some great family court appointees. They solve family issues quickly with little expense. I personally have had experience with a few of these. Let us now turn our attention to how groups of organized family court appointees and their associates have taken advantage of children and families in crisis by creating additional problems with long-term adverse effects on the mental, emotional, and financial health of the family unit. They do this by taking advantage of the family court system. They do this for long-term profits, power, and personal capital gain, just like any other organized criminal activity. In many cases, the court appointees easily create a biased paradigm that creates, feeds, or lengthens an already horrible family situation. They do this at the expense of suffering, abused children, and parents. And this is how they do it. In high-conflict custody court cases, family court typically appoints a therapeutic interventionist, a TI. This instantly creates a revenue stream for the appointee, a TI, therapist, psychologist, or court-appointed advisor. The length of time that revenue stream continues is highly dependent on the ability of the appointee to solve the problem. Do they solve the family problems quickly, or do they stretch out the problem? I've experienced both and have the hard evidence to back up these claims. This problem begs the question, is it the family court's job to fix families or to simply adjudicate according to Arizona law or their feelings? We believe these matters should be adjudicated adhering to the laws of Arizona and what is in the best interest of the child. The family court also requires each parent to supply an affidavit of financial information, or AFI, This discloses each parent's finances. The TI has access to the AFI. This is how they can size up the earning potential from each family. When the family court orders therapy, a TI is assigned. Typically, mother, father, and children are required to see a specific therapist assigned by the TI. This immediately sets the stage for multiple things to happen. A, required weekly therapy sessions ranging from $250 to $400 per hour on average for mother, father, child, or many children. At an average cost of $325 times the 3, that's $975 a week per family, or $50,000 a year if you take a few weeks vacation. It's purported that one TI has 97 cases in his case file. Multiply 50,000 times 97, near $5 million worth of income. It's a very lucrative profession, isn't it? B, supervised visitation. The costs vary. An example, $2,000 per month for 2 4-hour visits per month, or $24,000 per year. This is ordered in many cases. C, intensive family therapy, IFT. Estimated costs, mine was $15,000. I've heard up to $40,000 for these camps, or intensive family therapy sessions. In addition, new terms were developed during the course of my case. There were pre-intensive family therapy costs, post-intensive family therapy costs, and the names for more charges developed as the case went on. I've listed my case if you'd like to review it, the numbers there on the sheet. D, a false narrative, and this is a very important part. A false narrative is created by the TI favoring the abusive parent.
Yep.
This sets up continuous actions by the good parent to save the children from further abuse. These actions are like hearings, cases, more psychological reviews, whatever they can do to save the child from further abuse. This false narrative capitalizes on the instinct of human nature to protect their young, mothers and fathers alike. There's good and bad on both sides of the camps, right, of the genders. The good parent will spend and do whatever they can legally to protect the children from further damage by the abusive parent, whatever they can. They'll spend every dime. The false narrative paints the good parent as bad, and the abusive parent is good. This is typically reflected in false reports to the court by the TI. I'm going to repeat that. This is typically reflected in false reports to the court by the TI, and I have hard evidence of that.
I was just going to ask, Robert,
well as others.
is this your personal experience, or is this a generalized experience that is second or third hand?
Both.
Okay. Let's
Personal experience and experience from talking to more than 20 parents who have had the same paradigm applied to them.
I appreciate that. So let's try and stick primarily to your first person experience, okay?
It's my intention over the summer to dig out more cases to give you more hard evidence.
All right, thank you.
You're welcome. This results in the abusive parent getting reoccurring temporary custody through any legal means available. One is a reoccurring no-contact order. In my case and many others, a no-contact order was or are issued without cause or due process, which violates parents' civil rights. You have to have due process to take a kid away from someone, temporary or not. This perpetuates family conflict instead of resolving it. Here's an example, and I've listed a case for you here, of Sachs versus Raymond Brand. It explains exactly what I've described with bias and false reports. You asked, do I have another case? There is one. In addition, I have multiple instances where the handwritten notes obtained through subpoena of multiple TIs that are in direct conflict with the reports provided to the family court system. Hard evidence. The judge created orders using false reports, thus causing additional damage to the family, while the TI and his circle of influence, colleagues, and an army of therapists continue to profit from the weekly therapy fees collected. Remember, this therapy can go on for years, and has gone on for years. Number 4, a circle of influence has been created and used by TIs. There's a specific group I and many other parents are now aware of. These circles of influence are used repeatedly in many cases. The false narrative is reinforced through multiple mental health care providers that remain loyal to the false narrative proffered by the leading TI. Businesses referred and repeated case by case to therapists who align to the false narrative, thus creating a group that has conspired to mislead the family court system. I've experienced this firsthand. Others have described the same web of therapists that they were or are ordered to see. Another means that they use is psychological evaluations. They're misused as punitive measures, ordered without cause. There's a high profit in this. They're demanded by the request of opposing counsel, sometimes by the leading TI. In my case, the ineptitude of these highly paid appointed professionals is clear and repeated in many other family court cases. In my case, the court orders state, father is to get a psychological evaluation, or words to that effect. And you can pull up the case and see the order. No specific provider or timeline was ordered. Father did as the court ordered, using a highly qualified, respected professional in the field of forensic psychology, family psychology. Cost $9,000. The TI declined to accept it at the next hearing, declined it, and ordered a second psychological evaluation by a specific individual within his circle of influence at an additional cost of $14,000. By the way, no personality disorders were discovered. But
excuse me. Okay, so two things. No personality disorder was discovered in the first examination, correct?
Correct.
Nor in the second.
Correct.
Okay. This is just a general comment, not just for you, but for everybody testifying. We really need, and so far you've done a pretty decent job. We got to focus on facts and your experience, and not make allegations of crimes, because, and here's why I say that. The facts will reveal any potential for perhaps a referral. I don't want to jump to the conclusion that a referral is necessary until we have the facts as a foundation. Okay?
Okay.
All right, thank you. Please proceed.
I'll try to apply that as I understood.
You might have to kind of massage your remarks a little bit, but we don't want to make any criminal allegations at this point, because this is a fact-finding hearing, not a presumption hearing. Okay? All right, thank you.
So, no personality disorders were discovered, but additional 90-day no-contact orders were enforced, while the process dragged on for months. The second psychologist doing the evaluation decided to take 6 weeks and go to Africa. I was not allowed to see my son during that time. I had to wait for the second psychological evaluation.
Okay, excuse me just a second. Let's go back to the first psychological exam.
Yes.
Were you able to submit that to insurance? And
Hello?
Hola, lover.
How's it going?
Pretty good. You feel like going to the gym?
Yeah.
I want to eat something.
Okay.
I'm going to move the call. I'm going to be there about an hour. That sound okay?
Okay.
Hey, Louis. I just walked in here right in my son. But see about an hour. No. Okay. Oh, I did. Actually, I did. One job. That is it. The cover and decent size, plug, and a big ass pond. Yeah, this pond itself is probably not a little long, but better. Yeah, that's probably 3 feet, probably a huge ass ball that long. I might be 16-foot around. But anyway, I'll see you now. Bye.
Oh.
Club. Step to echo, cry loud. Join rise from the crowd. No chains can bind us, no walls hold us still. Our hearts beat as one within the room. Raise every voice so the world will hear. Silence the truth.
Children having reached the age of majority find themselves needing help to deal with the additional trauma caused by not only the abusive parent, but also the brainwashing done by the TIs who use dark psychology in their processes to reprogram the child to tell them their abusive parent isn't abusing them, it's all in their head. Then there is the emotional damage done to the good parents which can spawn the need for therapy to recover from the trauma of watching helplessly while their children are taken away, forced into the homes of the abuser to suffer additional abuse and brainwashing. Eventually, the good parents discover the brainwashing that the TIs have done to their children, making the child believe he is at fault. This is the goal I hear repeatedly. It is true in my case. They made my son feel like he was the problem, not the abusive parent. Testimony by survivors who aged out is available. See the video testimony, and I've cited Tori Nielsen, who spoke to the House of Representatives last year on 3/19/24. It's a very moving testimony. Please watch it. It'll give you greater insight into our problem that we're trying to overcome here. And that's all I have. I've got some sightings on the back page from my case, but.
Okay, Robert, if you would, please make sure that Zach gets whatever materials you've got to turn over to us, and it'll be a part of the majority report. Members, any questions for Robert?
Yes, I have a question.
Representative Fink.
I was actually part of the, or helped out the parents to be able to get the ban on the reunification camps. But I see this intensive family therapy. Did that happen right at the time that we were getting that bill passed? And is that basically the substitute for these reunification camps?
It went hand in hand with reunification camps. Yes, it was going on at the time we were working on SB 1372. So that was coincidental to my case. So my son, luckily, didn't get drug off to another state or trafficked to another state for a reunification camp. Victoria Nielsen did, and you can see her testimony if you didn't hear it before. Did that answer your question?
Well, yeah, I was there. But what I'm saying is that we banned reunification camps here. Is this intensive family therapy the loophole to be able to basically do the same thing?
I don't know. I only had 20 minutes of it.
Okay.
I just couldn't say. Other parents may be able to say.
Okay,
Speak to
thank you.
that.
Well, that's also something that we can research and try and validate. Okay. Members, any further questions? Robert, thank you very much for your testimony.
Thank you all.
All right, next up, Mr. Jeff Taylor. Mr. Taylor, good to see you again. If you would please give your name for the record and who you represent, and you've got 10 minutes, and I'm going to put you on the clock.
I can probably do it in 3. Thank you, Mr. Chair.
Excellent. I'd like to hear your time savings.
Okay. My name is Jeff Taylor, representing the Salvation Army, and I've had probably almost 2 decades of experience in family court, not for myself, but for our clients. So I've had a broad range of experiences, but what I noticed is that the family court system is really an industry. It's an industry to create extensions. It's an industry that will create increases in billable hours. So let's just take one case. So a woman's going to file a divorce proceeding. The papers are served. Now they've got 2 attorneys that run to the court to see who can get an order of protection first on the other person. And that just takes someone going to see a commissioner. Commissioners want to be judges, and so they want to err on the side of the caution. So let's say it's the woman. She says, I'm in fear. No reason to be in fear. He didn't ask, what are you in fear for? Order of protection is then placed, which now encompasses the children. Now that attorney has leverage over the other side because now they use the children as a weapon. And just to take this one case further, so there was an allegation of drug abuse on the one parent, the male. So the normal protocol was 8 random drug tests over a 2-month period. This individual did 106 drug tests over a 1.5 year period. All were clean, extending then the therapy and all of the other things that were ordered upon this person.
I'm sorry, I need to stop for just. So 106, were these a routine that was set by the court? Or is this something that he took upon himself to prove that he was clean? Or give me a little bit of context.
It was ordered. Thank you, Mr. Chair. And yes, it was ordered by the court, and that the drug test to be witnessed. That's very key. Witnessed drug test. That means somebody sees you give the sample,
Okay,
and
simple
that's what
math
this
tells
person
me
did.
that, I'm sorry, I didn't talk over you, but simple math tells me that's a drug test every 3 days.
It was twice. It was twice a week, approximately twice a week for a 1.5 years. All clean.
And they're throughout the entire testing regimen, there was not a hint of, okay.
There was only the allegation of a drug history, but no behavior.
Okay.
Then the family law attorney started to coach their client to make, because you have an order of protection, right? To start making allegations that you had to call the police. I think he's outside. He might be here. I don't know. 25 calls to the police.
Let me stop here. So this is, for all intents and purposes, this is speculation. I'm looking for firsthand experience that you observed. And if this isn't something that you observed, let's try and get back to where you observed something that you can report.
Thank you, Mr. Chair. I was in court with this individual for a 1.5 years. He was one of our clients.
Okay, I guess that's pretty close.
Yes.
All right, thank you.
And the allegations, Mr. Chair, of calling the police, this individual was in our program with the sign-in, sign-out sheet and couldn't be there, was in our residential facility. How this person stayed sober through this experience is beyond me. There was no opening up, or there was no reward for the hard work that this individual did to handle his addiction. There was no payoff. But during that time, the judge ordered supervised visitation along this way. In the second report from the person doing the supervising, it said, I see no reason for this person to be in supervised visitation.
Where did that report come from that said that?
From the individual that was doing the supervising. So the judge ordered the individual to have supervised visitation, which the individual did, and started this process of supervised visitation after a year of drug tests that were clean. And in the second report, which were weekly, Mr. Chair, in the second report, it started off with, I see no reason for this person to have supervised visitation.
Okay, Jeff, just for clarity, and I'm sorry, I'm trying to make sure that I understand the timeline here. Second report, the individual that the court appointed to supervise tells the court no reason to continue this. Yet the court continues to call for the drug test. Was there anything else besides the drug test? Was there mandatory therapy? Was there mandatory intervention? Or was it just the drug test?
Mr. Chair, the therapy the individual was in was a 6-month residential drug treatment program, and now is in transition. So still in a program, long-term residential treatment. So I went with the individual to court to bring to the court's attention the second report stating there's no reason for this person to be in supervised visitation. And the judge, when questioned, have you read the report? The judge hadn't even read the report and kept those same orders in place. Hadn't even read the report that that judge ordered.
The judge's name?
Well, there were 2 Reinsteins at the time. There was a really good Reinstein, and there was a not so good Reinstein. And all
Don't pass judgment. I'm just looking for a name.
Pete Reinstein.
Okay. All right. Okay, your 3 minutes is up.
Thank you, sir. And thank you for taking on this issue. Members, thank you for your time.
I appreciate your testimony. All right. Next we have Mr. Monty Schultz. Mr. Schultz, if you would, please give your name for the record and who you represent, if you represent somebody other than yourself.
My name is Monty Schultz. I'm a licensed clinical social worker in Prescott, Arizona. I'm also a licensed independent clinical social worker with a Nebraska license. I appreciate the opportunity, Senator French, and the Representative Cashel, that you chair this type of hearing. I've seen these issues. I've been a social worker for the last 14 years. We just moved here 2 years ago, and I didn't think that I would be involved in this type of hearing again, as this issue is nationwide, right? Yes. And you are taking the initiative to address some pretty significant problems with the family court system. I've been through.
Mr. Schultz, you moved here from
Nebraska 2 years ago.
Okay, and I think what I hear you saying is you moved away from a similar problem to a similar problem.
This court is this issue is nationwide, in my opinion, right? I mean, I've testified as an expert witness in Virginia. I've been involved with the TI system in Colorado. I've been involved with it here as well, even though I choose not to work with children anymore, and this is one of the reasons I do not. In my humble opinion, I do believe children are being abused in this system, right? Kids have rights too, right? And we are, in many cases, taking fit parents out of the lives of our children, right? And it's done as a grift for the court system. It seems like, as I've experienced the system here in Arizona, I'm watching it as, or seeing it as, we appoint these TIs. Are they really mental health providers, or are they investigators? Right? And if they're investigators, do they have the credentials to investigate? This bill 2256 was regarding parental alienation, which is something that should be considered abuse, right? So if they're investigating parental alienation and not reporting this to the agency that is statutorily required to investigate abuse and neglect, who's the investigators, right? So here we have a problem with the family court system. We had another individual come up and say that judges are not statutorily required to
report.
Make a referral.
Make a referral for child abuse. Thank you. There's a moral problem with that.
Yes.
Right. These are individuals who are first lawyers, who are probably statutorily required to do this and become judges. Who's getting rich within our system? Right? It's lawyers, and in Arizona, it's TIs. Right? This is a grift. I bill insurance for my services. On average, I make from $60 to $110 per session. Right? I'm glad with that. I'm okay with that. These people are making upwards of $300 per session, right? And they can't bill insurance because it's court ordered. But however, I'm not sure that that's really accurate, because I've had people that have attended my sessions with me that are court ordered to be in therapy, and insurance companies pay for it. So it's really the issue of how much they're getting paid.
Monty, it just occurs to me, if I think I hear you saying that to hide behind the court order aspect of ordered therapy may relieve a therapist from having to abide by certain insurance company requirements or regulatory requirements?
Absolutely. Yes.
Okay.
When you're credentialed with an insurance company, you agree to provide services
within guidelines.
Within their guidelines.
Okay.
Mr. Chairman, usually it's called usual and customary fees that the insurances will pay. And so therefore what I'm understanding is that they charge so much more, therefore they would not get paid because it's beyond the usual.
Well, beyond that, here's the real issue with the insurance. If the insurance company is willing to pay $100 for your services and you bill $300, there's no mechanism to collect the other two, because that's against the insurance guidelines, right? So therein lies the grift. Right. If you're doing this for a fee for service and you're charging $300 for this per session, with so then you're making 3 times the amount of money, right? And again, the kids are the ones that are losing out on this, right?
To your point, thank you for rescuing me on the term. I appreciate it. Okay, Monty, we've got 2 minutes for you to finish up, if you would put a bow on this.
Okay, here's the thing. We're talking about GALs earlier, and GAL training. We're talking about training for TIs. We're talking about training for lawyers. If you establish this in your bill 2256, right? You have to look at where they're getting that training. More likely than not, it's all at the same place. And so they're all like-minded, right? And so are we going to end up in this situation of repetitive problems with the family court system, because they're all receiving the same training and there's nobody from outside the system able to work within that to provide a check and balance for the TIs that are currently doing this, the lawyers, all of this, right?
Would it surprise you to know that nowhere in Title 13 is there a reference to a criminal act called parental alienation?
No, it would not. It would not surprise me at all.
So that perhaps explains why certain individuals are not duty bound to make a report, because there is no such crime.
However, there is a crime for psychological abuse. However, right, it's almost impossible to prove that. My wife worked for Health and Human Services for 20 years as an investigator and as a supervisor for juvenile parole and abuse and neglect. 0 cases of psychological abuse.
Well, and I think to that point, it's being used as a weapon.
Yes.
To say that they're basically weighing psychological abuse or parental alienation versus physical abuse in a lot of these cases.
Absolutely, and it seems like to further that, it seems like the court system is appointing these TIs as case managers versus using the judicial system to solve the divorce and custody issues.
I'm going to throw a hypothetical at you, and if you prefer not to answer it, I'd appreciate it. Just be very frank. If you are an individual making a recommendation to the court about somebody that the court has asked you to look at, a recommendation for therapy or extended something, I don't know what all the options are in your world, would it be inappropriate for the court to turn around and order you to provide that care?
In my opinion,
for failure of an arm's length transaction?
In my opinion, yes. Right. And here's the reason why, is because if the court is ordering me to provide a service, I'm providing that service. The court is supposed to regulate coercive practices in family court. At that point, are they doing that?
Mr. Chair.
Thank you.
Mr. Chair, I have a question.
Representative.
So in your opinion, I have heard from various parents, but that these TIs have immunity. And the explanation that these parents have received, why do they get immunity, is because that nobody else would do the job, so they need to have immunity.
No.
Is that what you've heard, or is that what you have seen?
That's what I've heard, and I don't understand if they were practicing within the guidelines of, say, the APA or the NASW. Why do they need immunity?
Exactly.
That's my question.
I don't have immunity.
Yeah. Okay. Thank you.
That's perhaps one of the most interesting observations made today.
Yes.
Why? All right, members, any further questions?
I have
Thank you, Mr. Schultz.
Chair.
Senator Toffley.
Thank you. Thank you very much for your testimony. My question is, how are these fees, how are they assessed when we talk? And you made a reference regarding, or well, you did it, but the prior individual did, how individuals have to submit their finances. Is there a correlation between that information that's submitted and how these court appointed advocates or advisors, which also include the TIs, do they use that as a way to establish their fees? I don't, that's what I want to know.
I don't know the answer to that question because I'm not a TI, nor will I be a TI. For the reasons I've talked about here.
Thank you.
Okay, members, any further questions? All right. Thank you, Monty. I appreciate your testimony. Just, I suppose, an observation. Once again, we go to this question of quasi-judicial immunity. And I would substitute authority for immunity. And the delegation, now there's a non-delegation doctrine for the legislature. In fact, where that came up is the Chevron deference opinion out of the Supreme Court, that the legislature cannot delegate its responsibility to agencies. It occurs to me that
he fucking did it.
And perhaps this is something for the legislature to take up in the next session. Why then are judges permitted? I mean, these are supposed to be the arbiters of, the neutral arbiters of questions of law and fact. Why then are they delegating responsibility? This is tracking well with what you had suggested, that perhaps they're case managers, they're not actually offering therapy. They're acting more like traffic cops to send people off to get out the checkbook and pay for services. Sorry, that's an observation. I guess one of the questions that I've got for you tracks along with the idea of a guardian ad litem or representation for the child. Because I think what we've heard so far is that this is all about the adults.
Yeah.
I've not heard a single person talk about the kids, not one, other than parents. So that gives me grave concern about the focus of the family court orders. Do you think it's appropriate, or should it be, in your professional opinion, should it be the state's responsibility to appoint a guardian ad litem, I hate to use guardian ad litem because that's got a very specific connotation, but representation for the child in this? Once the court has entered into this therapeutic regimen, it seems like there needs to be somebody representing the interests of the court. If you would mind commenting on that before you walk away.
So I'm not sure that the typical term guardian ad litem usually means attorney, right? Other states expand that a little bit and will allow professionals in my field to serve as like advisors to that youth, right?
Yes.
So I don't know if it's if it's a good thing or a bad thing. Because again, you have to look at where these individuals receive their training for family court, right? And it seems like in Arizona, there's not very many places, and they're using one specific place.
Okay.
Well, and really quick, Mr. Chair, to that point, if we start talking about getting a guardian ad litem, we need to be really careful. There's a lot of research done that a lot of times they're not even talking to the kids. There's a whole documentary Undercovers that specifically looks at how the corruption is right in the middle with that person. So we would definitely, I think we need something, but we would have to definitely regulate that and really know what we're dealing with.
And who's going to pay for it?
Yeah, sure.
Okay. Thank you, Bonnie. I appreciate it. All right, next up, and I probably should make an announcement right now. For those of you who have grumbling stomachs, lunch is available out on the Senate lawn. You can't eat or drink in here.
Wow.
But if you find that you need sustenance before 12 o'clock noon when we break for lunch, there's lunch for purchase out on the Senate lawn. And by the way, the Senate does not make a penny off of it. Okay. Now you can laugh. All right. All right. Next up is, yes, there was a reference to an arm's length transaction there. Next up is Steve Alcott. Mr. Alcott, are you in the room?
They're doing the professionals.
If you would please come to the microphone, give your name and who you represent. Oh, you don't want to talk?
Court stuff. Yeah, they're talking about how they stuff.
Okay. Great.
And
We
the
just saved some time.
professionals are talking about how family court
Next
makes
up,
money.
Vivian
All the
Miller
professionals are talking about it.
and
And then
Claudia
let the
Reddy.
psychiatric board, they give them 15
Forgive me if I
minutes at the
butchered your
beginning
name,
and
ma'am.
talk about how they do things.
If you would please come to the
And then
microphone,
the guy
give your
said,
name
in 20
and
years,
who you represent, if you
there's
represent
never been
somebody
one,
other than yourself.
what did he call it? Psychological abuse case, not one. It doesn't exist because they're the ones taking the complaints.
Oh, there's a little switch right there.
This might be apparent.
Just push it down.
It would have the first
And it'll
one.
go down. There you go. All right. And if you would get as close to the microphone as you can when you give your name and you're speaking, okay?
Hello, thank you. Hello. Thank you for having me here. I'm Viviana Miller. This is Claudia Reed. We are part of a sect of Me Too Court 383 in El Paso, Texas. We're here to support for all victims of family courts. This is a nationwide problem. This case began with an ex parte order, which is very familiar in a lot of cases where an ex parte order is being filed. To this day, in which I was never given due process. let alone a day to fight these accusations, in which my daughter was forced to move here in Arizona with someone who was a stranger, who is now our accuser.
Yep.
This order, in fact, was random and out of the blue. Upon hiring an attorney, being told continuously by many attorneys actually who should be holding up their ethics but do not, that I would not stand a chance unless I go through jury trial. In which everybody knows jury trial costs more than $20,000.
They don't fucking exist. They don't exist. That's a
But in the end, the judge will still decide the parenting time. Despite going to jury trial, the judge will still decide.
No, jury trial
And
don't
that's in many
exist.
cases. In my personal case, the opposing party's attorney is the judge's campaign treasurer.
There you
in
go.
which many parents are dealing with this judge and this attorney hurting their children with their abuse of power. Children are being mentally abused, physically, spiritually, and sexually, all under these court systems who do not care and threaten them for speaking up.
Yes.
To these judges and attorneys, every child is merely just a dollar sign.
Okay, ma'am, if you would, please contain your comments to your personal experience.
Yes.
That's what we really want. That's where the meat of the matter is, okay?
Yes.
I know that you came a long ways to testify.
Telling the judge's
but
name, your
that's-
attorney's name.
That's really what we want to hear about,
the
is your
social
personal
workers.
experience.
Okay.
Come on. You can do it.
Not just in, there was an instance where I was told to file the grievance by the DA in my town.
There you go.
And because the opposing party's attorney made a false email with his email a part of it. He told me to file the grievance, and when I did so, my current attorney that I had withdrew because her words was because I have to look out for my family too. She was indeed afraid of retaliation, and I did have that in an email where she was afraid of retaliation.
And I'm sorry, retaliation from?
Against the judge.
From the judge?
Yes.
Okay. just
Who's the judge?
time out.
Come on.
Because she was representing you, I
Yes.
presume you believe to the best of her ability,
Yes.
she experienced some level of fear of retaliation?
Yes.
Would that be because she wasn't going along to get along?
They tried making it a false email, trying to say an email clarifies as a court order.
Yes.
And I brought that to the DA's attention. And the DA said, file a grievance because his name was on there. And when I did so, she withdrew.
I'm sorry, file a grievance because of why? What was the?
For trying to say an email was a court order. It wasn't a court order.
Oh, okay, so somebody misrepresented an email as a court order in order to try and compel you to do something.
Yes, sir, the opposing party.
And when your attorney brought that up, the court didn't want to hear of it.
I had taken it straight to the DA of what do I do next, because the DA was my previous attorney who was working on that order. So when I brought it to him, like, hey, they're falsifying your email in this email saying that you agreed upon this, what do I do? He went and said, file a grievance. And when I went to go file a grievance, she called me immediately, hey, you did this, I need a withdrawal. Because I have to look out for my family.
Okay, so this wasn't the attorney, this was the therapeutic interventionist.
Attorney.
This is the attorney.
The state's DA, buddy.
Clear, sir. Okay. All right, I think I'm following you now. Discussion.
Mr. Chair, just for a point of clarification, is your case still in Texas, or is it now, is the jurisdiction here in
We
Arizona?
are looking to move it here in Arizona.
But currently it's in Texas.
Currently in Texas, because this is a nationwide problem, we came in here for support.
I really appreciate that you're here. Thank you.
Okay.
And,
Senator Warner. Ma'am, time out. Just got a question.
Where is your child?
she's here in Arizona, Phoenix, Arizona. She was forced to move here in Phoenix, Arizona, with someone who was never a part of her life.
That's what they do. Interstate
Okay,
trafficking.
point of clarification.
Child trafficking.
Your child is here in Arizona with a non-parent?
No, it's her father. Her father, who was never a part of her life. He was, I can't say never, he was maybe 3 times a year.
Okay.
And it was very random.
Down the path of other parents.
Yes.
Okay. The question is well taken that your daughter is here in Arizona and you're trying to move the case from Texas here to Arizona, correct?
Yes.
All right, thank you. Please finish up. You got about 2 minutes.
Many of us parents in the court have a gag order because they don't like the children to speak up or the parents to speak up as well.
I'm sorry, this is a court in Texas that has a gag order?
Yes.
Okay.
We are here in support that this is a national emergency, to be the voices of the children from Texas and all over who are suffering, including my own, who was forced to move here in Arizona. Yes, children are resilient, but upon those words, we are turning those same children into adults with problems. It starts with us. We have to do better. These children are learning to lose faith in the same adults who are supposed to protect them. This is a system that should protect them and not exploit them or profit off of them. And that's all.
Thank you for your testimony.
Thank you so much.
Ma'am, do you have something to add, or are you
Just say something.
basically the ditto?
It's really short.
Okay, please give your name for the record and who you represent. And you've got like 5 minutes, okay?
My name is Clara Rede. I am from El Paso, Texas. I decided to come here because my granddaughter was removed from her mother by an ex parte order and relocated to Phoenix, Arizona. My granddaughter's father's attorney happens to be the judge's campaign treasurer.
There you go.
To my granddaughter, my granddaughter was never in immediate danger. I just want to say, Arizona, you're not alone. The family court crisis is a national problem. Many of the issues heard here are the same issues we have in El Paso, Texas. I feel the biggest issue is family court judges having immunity and no real accountability in their actions. Judges handing gag orders with the threat of time lost with the child. Judges given the power of discretion and not always based on law or the best interest of the child. Thank you for allowing me to speak.
Thank you both for coming. Members, any questions?
Mr. Chair, I'm just curious because usually gag orders I hear more criminal cases. So what was the basis and the authority to be able to issue gag orders on parents and the child?
There you go.
To protect the privacy of the child.
Okay. Thank
That's an interesting twist, all right?
Yes, it is.
All right, thank you, ladies, I appreciate your time and your testimony. All right, next up, we have Mr. Martin Lynch. Mr. Lynch, you in the room?
I think I know him.
If you would, Mr. Lynch, please give your name and who you represent, if you're representing somebody other than yourself.
Mr. Chair, members of the committee, we appreciate your efforts to search for solutions to what we all know are pervasive problems.
Come on, who are you?
My name is Martin Lynch, and I represent We the People Court Services and the NAACB, which is another court reform organization. I made a copy of a report that was published in 2005 for you to look at the details.
NAACP, who he's with.
Because there's a historical record that shows that the problems that we're dealing with now have been around, and they go back as far as you want to look. And it has to do with checks and balances, or specifically the lack of checks and balances, because absolute power corrupts absolutely. So any individual human being, that includes judges, lawyers, legislators, governors, everybody, that thinks that they have unlimited power to do whatever it is that they want to do, well then you can expect to have a meeting like this. So I just wanted to point out that what we're dealing with is a problem that goes beyond just family court. It has to do with the violation of separation of powers, where we expect to hire an attorney, and that attorney is going to represent us because we're giving him good money, and a lot of it. And come to find out that the lawyers and the judges are all part of the judicial branch of government, and that's in the Arizona Revised Statutes, Title 32, Chapter 2. If you look, that piece of legislation is no longer around, it's gone.
They still use it.
What happened to it was, it used to be the regulation of the legal profession by the legislature, along with the other 40 regulated professions that are in Title 32. And so they took it out. And what that did was it allowed the judicial branch of government to usurp the authority that rightfully belongs to this body and to the people through our elected representatives. And so now what you have is lawyers and judges who are all part of the judicial branch of government, and their job is the job of the lawyers is to take the money, and the job of the judge is to help them do it. And then what happens is that later on, these lawyers become judges, the lawyers or the judges retire, go back to practicing and making all the money.
There you go.
And so you can see that it's a revolving door of conflict of interest. And so if you have lawyers that are representing all these different organizations, including giving legal advice to our own legislature, if these people are compromised with the conflict of interest, well, then the wheels have come off the entire system.
There you go.
And so the real problem is we come to the legislature, and Representative Cashel can tell you all about it, is we come to the legislature and we say, okay, we're going to put checks and balances back. That's all we need to do. And we have a bill, and it goes to, it gets assigned to a committee, and then for some reason or another, or no reason, it's because it's all done in secret, is that bill is not heard because somebody told somebody something in secret, and nobody knows what was told. There's no debate, and so we're in a catch-22, and that is the foundational element of it, is we cannot get our legislators to put a bill out there to restore checks and balances. And,
community, put it into the bar.
Excuse me, Mr. Lynch, do you have a specific bill number that you're talking about? Oh,
He said there
I'll
isn't.
just check with
Nothing's going to
my
fix
partner.
it.
And there
So
were
you
bills
abolish
prior to
immunity.
this dating back, I'm going to say 7 or 8 years, where we've been down here working these problems. And that's how we've established that we can't get anything done here because
There you go.
the system's compromised.
So
Yes.
you look like you might be old enough to know. That no offense. No offense.
Sadly, I am,
Sorry.
most likely.
I meant to say you look like you've been around the block a time or two. But never mind. You've got historical knowledge, tribal knowledge. Do you happen to know when approximately the move in Title 32 away from the legislature into what presumably I would say is
60
probably
years
the bar?
ago. Tell him.
Do you know about when that happened?
Come on.
I don't. I do know that Article 6.1 of the Constitution, which was brought up by April Elliott, because she represents the CJC, came about, I think, in the 80s. And that was a solution
She
that
got
was
40
thought
years ago.
to bring a resolution to the problem that we have, because then judges would have oversight. And she just came in here and told you that they have no authority, no jurisdiction to do anything about the decisions of a judge in any particular piece of litigation. They can work around the edges if the judge is crazy or if he's yelling or screaming or whatever it was that she told you. But when it comes to an appellate action, they have nothing to do with that. And then the other thing that we found out is that in these appellate actions, even if you're quote-unquote represented by an attorney, if that attorney does not set up your trial court case properly in order to prevail in the Court of Appeals, well, then when you get to the Court of Appeals, they throw it out and say, oh, I'm sorry, the thing wasn't pled properly at the trial court level. And this goes on over and over again. I have to show you examples of it, where the Court of Appeals, Arizona State Supreme Court, ruled that because the lawyer didn't do what they were supposed to be doing, now we can't help you. And that was a DCS case. But, I mean, the failure mechanism is ubiquitous across all these courts. It's DCS, family court, guardianship, probate. It's everywhere.
And forgive me, but it seems like that would be, I know it makes absolutely no sense. Who would you go to? The court. If you were to challenge the lawyer's authenticity and qualifications, basically defective representation. Where are you going to go? The court?
We go to the state bar.
Yeah.
And then the state bar is going to tell you, and I think one of the ladies here said that out of all the complaints made to the CJC, 485, 3 were valid. So in other words, there's no enforcement going on there. The state bar is the same. Go ahead.
There is a difference between the judicial performance folks and the bar, although it may be a very thin veil between the two. I've had plenty of experience with the bar, and I know exactly what you're talking about. So that's another problem altogether. Okay, you got about a minute to, let's try and wrap this up.
Board of psychologist examiners, I have firsthand experience there. I had a psychologist who recommended that I furnish pornography to my teenage son. So I go, that doesn't even sound right.
I'm sorry, time out. Who said that?
A court-appointed psychologist.
Can you reference a case?
My own personal family law case.
Okay, that's close enough to first person.
Yeah.
All right.
Yeah, I mean, I sat in the office and listened to him, and I said, what should we do about this? He says, well, we should furnish him with acceptable pornography. That's what I listen to. And I go, what is that? And so I do my research, that's how I am. And I find out that that's a criminal act. And so we went to the Board of Psychologist Examiners, and they said, I know none of these people are probably lawyers, but the results that I have documented was that when the judge appoints a psychologist to one of these cases, that person who's been appointed is now sheltered by judicial immunity. They now have the cloak of judicial immunity, and any kind of enforcement of their code of conduct belongs to the judge.
Yes.
They said, we do not have jurisdiction once that court order is issued, giving them an appointment to this
Then they
case.
give them power.
So the Board of Psychologist Examiners can tell you, oh yeah, we can do this, we can do that, we have all these different things we can do. Well, none of it applies once there's a court order for a psychologist to become assigned to the case.
Well, with all due
They don't
respect
tell
to
you
you,
that. Go
I
ahead.
don't give a bloody damn what the court wants to say. When someone is engaged in a criminal act, quasi-judicial immunity does not apply. You're committing a crime. That's like saying a judge who orders the very same thing is exempt because they're a judge.
Correct.
Not in this state.
So we did a criminal referral. We've been to the FBI up on North Black Canyon Highway. And all these law enforcement agencies say, well, you know what?
They won't do anything.
Let the judge handle it.
Yes.
Or they say, we're too busy protecting the country from terrorism.
Yes.
And it's like, wow, okay, well, I think I have terrorism here, but, you know. So in other words, they have prosecutorial discretion. And that's a principle that we want to defend. We don't want to throw it out. However, we're looking for checks and balances here, and they do exist. They are in here. But if your lawyer is not prepared to do what's necessary to, number one, make the trial court case subject to an appeal, and number two, to take the thing to the appellate court. And then the lady just before me said that the judges exert coercive control over the judges. I'm sorry, the judges exert coercive control over the lawyers. And so we're back to Title 32 again, which is blank. Chapter 2, which is blank. And I'll just add on one last note. I keep hearing best interest of the child, best interest of the child. In the Constitution, it says due process and a bunch of other things. It doesn't say anything about that. But there is Supreme Court case law. One is Troxel v. Granville, and the other one is Santosky, where they establish that the primary, most inalienable right that all the people have is to parent their own children.
Yes.
And so that serves our interests.
Yes.
And the problem that we have is that this best interest of the child thing is an artificial construct and is subject to the unlimited interpretation by a judge, one person. And when you get into this court of equity, then
you got it.
All of your rights go out the window, and you're subject to what that person invents as what they think they need to be doing. And once you understand that the lawyer's job is to take the money, and the job of the judge is to help them do it. This is the unspoken rule. And so they have this revolving door going back and forth and everything. And it's not something that we haven't seen in a bunch of other areas of our society. And so I just thought I'd just throw out that we have looked at what we need to do to fix this thing, and individual pieces of legislation have been blocked by something secret going on behind the scenes, and there's something called the Department of Government Affairs that's over at 1501 West Jefferson, across the street over there at the Supreme Court building. And those people's job is to come over here and tell you what needs to be put into the statutes. And so until we can rein in these violations of separation of powers coming from across the street over there, then we can come down here and ask you to do stuff forever, and we're probably going to have another meeting like this 5 years from now. Who knows?
Well, Mr. Lynch, actually, we're going to have 3 more of these, and we're going to continue to try and unpeel the onion.
I love you.
Quite frankly, between the last installment and this one, there is a picture that is coming into focus that is actionable by the legislature.
In the ball.
Don't think that the folks across the street have more power than you do. I want to assure you, in the words of Supreme Court Justice Ruth Bader Ginsburg,
there you go.
The people are the ultimate legislature. So your testimony here today, the testimony of these folks, is extremely important, because this is not, in my view, a political matter, but politics certainly is in it.
Yeah.
Representative, I'm sorry, Fink, you have?
Yes. Thank you, Mr. Chair, and thank you, Mr. Lynch, for coming. I believe that parental rights, you kind of said what I was going for. I consider kind of the Ninth Amendment right, because the founders didn't want to, they were concerned that they might not have written down all the different rights. And so they have the Ninth Amendment right. I consider parental rights a Ninth Amendment right. And we've had discussions back and forth. We had a bill in regards to a jury trial, because it is a self-evident truth in regards to, parents and parental rights. And we've heard people say, no, let's just want to do a jury trial. Yes. What are your thoughts on that?
Well, the limits of the power of the judge, let's talk about all these enormous fees that people are, one after another, coming up here telling you they're all going bankrupt. Bankruptcies and suicides are like another topic. When it comes to veterans and active duty military, there's a Department of Defense report that talks about how family court is one of the root causes for all the suicides you're seeing in the military. So this is something that you can put your finger on.
Mr. Lynch, could you cited this DOD report, could you get that to me, please?
Okay. But I will tell you that the biggest check on the power of these people to take all your money is in the Seventh Amendment. It sets forth a dollar limit that the judge has unlimited authority to take your money. And there's a dollar limit in the Seventh Amendment over which the judge no longer has that authority unless you do not demand a trial by jury. In other words, I don't need legislation. I could go right here. And it says anything over $20, well, that authority belongs to a jury. That's what it says. Okay, but if you don't have an attorney who's willing to say, well, you know what, $20,000, that sounds a little bit much. Here, we want a jury to decide if you're going to take my children away unless I give $20,000 to your friend over here. And that's when, and this stuff is going on right now, and it's not something you hear about, it's not something that's publicized, but it is in individual cases where these cases just resolve once you take their authority to steal your money away. Why are they messing with you? Why don't we just get rid of you and go on to the next poor person who doesn't know that we can't just arbitrarily take your life savings away from you? So,
and to that point, Mr. Chair, also in the Arizona Constitution, there is also the right to trial by jury as well. So I think that is something that is supposed to be the check on a lot of these abuses.
Mr. Chair, I need one before we let you go, Marty. And you've been at this fight for before I was in the legislature. So thank you for doing that. I need a point of clarification what you talked about. I think you said Title 32, that it just disappeared. What do you mean that there was something on the law books in Arizona that just, I really want you to clearly say.
It's the regulation of the Chapter 2 of Title 32. Used to be the regulation of the legal profession as prescribed by our elected representatives through the legislative process. That's what it used to be. But somebody came in here and said, oh, you guys need to get rid of that because we're smarter than anybody else, obviously, because we're judges. If you don't believe me, ask one of them. And they say, well, we'll go ahead and regulate the legal profession because it's so hard and difficult to understand, only we can understand it. And what we understand right now very well is that this whole system, this whole process has been co-opted into a money-stealing operation. That's what it is.
Well, and I think to that point, Mr. Chair and Marty, I know you had a piece of legislation that you ran, I think it was my first session, about having to do with the court being able to lobby us over here in the legislature. I have no idea how one branch of government is allowed to lobby another branch of government and affect all of you. I don't understand that. They say that they don't lobby, they only lobby when it has to do with fees. Do you believe that to be true?
Not at all. I mean, I've sat in this room where an elected representative would say, well, they have somebody who present a bill, and I don't remember the specifics of it, but I think it was February of last year, and they said, and one of the representatives here said, the senators said, well, I've got to find out what the courts think before I vote. And it's like, oh, okay. Well, you better do what the courts tell you to do. We all know that.
Yeah.
And because
they take your
lobbyists run around here like they belong here, when the fact is, anybody that knows the Constitution or is interpreted by high-level court rulings knows that you guys don't belong here at all. Get out of my office. What's the matter with you? Was this a stupid test or something? I don't know. Get out.
Your point's well taken. There's a reason that the Constitution, in fact, ladies and gentlemen, we're going to have a little Constitution question here. Article 1 is the legislature, for a reason. It's closest to the people. Article 2, the executive. It's supposed to do what the legislature tells it to do. Execute. Article 3, the judiciary. They're there to call balls and strikes. Did you break the law? Did you not break the law? This notion of 3 co-equal branches of government is a progressive era falsity. It is a fiction. So for the legislature to bow down to another branch of government, your point is well taken, sir. That is not our job. Our job is to represent the interests of the people, and in this regard, the interests of children, especially. Because who else are they going to turn to? You got 2 parents, please don't take any offense, they don't like each other. They don't want to be together. But there's still a child that's misrepresented in this whole affair. So, Mr. Lynch, thank you very much. I want to make sure that we get another couple of parents in before we break for lunch. Okay, next up, I appreciate it, and if you would, please get that material to my office because we want to include that in our report. All right, thank you.
Mr. Chair, to his point real quick, I had a bill for administrative courts to have a trial by jury, and I did have the legal, the judicial branch coming, not wanting to do that.
Yeah, well, we can talk about that offline. All right. We'll get it on the record at some point, but not today. All right, Atalia Durfield? Atalia? I probably butchered your name. I'm sorry. Hi. If you would you please come up and let's see. You're going to have to bend the microphone down just a little bit. Get it as close as you can. I take it by your appearance you may not be over 18.
No.
So you are a minor.
Yes.
Would you please give your name for the record and tell us your story? You have 10 minutes.
Okay. Good morning, members of the committee. My name is Talia Durfield.
Get as close to the microphone as you can.
I'm 16 years old. Thank you for giving me the opportunity to share my story with you today. When I was 5 years old, my parents got married. I remember being so excited when we moved. I had never lived with my father before. My excitement was short-lived. My first memory of my abuse, I was around 6 years old. For the next 7 years, I endured so much from my father. When I was 13 years old, my dad was living out of state for work. He had been doing so for months. My mom decided to file for divorce. Once she did, he moved back to Arizona immediately, demanding 50-50 custody of my younger sister and I. From the very start, I made it clear that that was not what I wanted. I spoke to countless professionals. I told the courts that I had been severely physically and emotionally abused by my father. I spoke about how I had been hit, screamed at, called names, grabbed, or shoved. I often felt like I was walking on eggshells in my own home. I lived in fear, and I carried that fear with me every day. I begged the court not to make me go back because I was and am terrified. My father was given supervised visitation with my sister and I. The supervisors claiming I would be protected and that my boundaries would be respected. They were not. I was appointed a court-appointed advisor. I spoke to her only twice, once in person and once over the phone. I tried to be honest about my experience. I wanted to make her understand why I didn't want to go. When she spoke in court, she spoke out for me. She asked the court to take my wishes into account. My father was given unsupervised parenting time and joint counseling with me despite this. I didn't want to go to the counseling, but since it was court-ordered, I went in open and willing to try to repair our relationship. But it quickly became clear that I was the only one trying. In those sessions, I was gaslit, lied to, and accused of making things up. The therapist and my father seemed to gang up on me. It felt less like counseling and more like giving my father permission to continue treating me poorly with the therapist as a witness. Even though my court-appointed advisor advocated for me, even though I told the truth about what I had been through, and even though I made my wishes clear, the court still gave my father unsupervised time with my sister and I. I felt invisible. I had done everything they asked of me. I spoke up. I shared painful memories. I trusted adults with the hardest parts of my life. But none of it mattered. It felt like no one believed me, or worse, like they believed me but didn't care enough to protect me. The message I got was that my voice doesn't count, that my safety doesn't matter, and that what happened to me isn't important enough to change the outcome. All I ask of you is to listen when we speak and protect us when we are afraid. Thank you.
Thank you, young lady. Members, any questions?
I'd just like to make a comment, Mr. Chair.
A comment or a question? I'm sorry, I'm having a hard time hearing you.
A comment.
Yeah. Get right up into the microphone so I can hear you.
Oh, yes. I just want to say thank you. Thank you for your bravery and for coming up and telling us your story. Really appreciate it. Thank you.
Senator?
Thank you for coming and sharing your story, and continue to be brave and keep sharing. Thank you.
You got a lot of courage, young lady. And after speaking with a number of, as the court would say, minors, you are just as articulate as any adult I've ever met. My compliments. Thank you for coming today. All right. Okay, next up, Tia Korick. I know you want to bust out with the applause, but if you want to compliment her at noon, we'll be breaking for lunch. You probably want to talk to that young lady because she's an up-and-coming leader. All right, Tia Korick. If you would please give your name for the record, who you represent, if it's somebody other than yourself, and get as close to the microphone as you can. All right?
Okay. I apologize. My name is Tia Carrick. Her story reminds me a lot of my daughter, so I am apologizing in advance because that does make me really emotional to hear.
It's okay. We're all a mess.
So thank you for the opportunity to speak today. I'm here to share my experience with the family court system, not just for myself, but for the countless families caught in a system that too often fails to protect children and punishes the very parents trying to do the right thing.
Hey, Tim, you can slow down a little bit. Okay.
Sorry, I'm not a great public speaker either, so
That's
I
okay.
apologize.
I'm not going to put you on a time limit. Just know you're the one between lunch and these folks. But that's okay. But that's okay.
Okay. I'm here. My journey began in 2017, but the true nightmare started in 2021 when my children disclosed abuse. I did what any responsible parent would do. I reported to police, DCS, and the court. Instead of getting help, I was punished. My children were taken from my care and placed with their abuser simply because I reported the truth. The police initially refused to investigate and told me to get an order of protection. A judge...
What police department?
Peoria Police.
All right, thank you.
Well, actually, it started with Phoenix Police that told me that Peoria Police is the one who actually investigated everything for 3 years up until current.
Okay, I was just looking for a reference of where this occurred.
A judge granted it, but only for my daughter, and refused to include my sons, sending us to family court instead. Just 2 months later, despite the order of protection being in place and never appealed, the court gave full custody to their father. A court-appointed advisor and best interest attorney were assigned. Neither ever met my children, reviewed medical or counseling records, or visited their schools. They submitted biased, even falsified reports. They were exposed in court, but no action was taken. When I brought my concerns to the procurement department overseeing these contracts, they admitted they were not monitoring compliance, including whether or not professionals even had active insurance as required, and nobody was monitoring their caseloads. I have done my own research that many of these court-appointed advisors are earning millions of dollars off of children. They are not ever meeting the kids, but getting a paycheck to do so. The day after custody change, my daughter was kept home from school. She was verbally assaulted for speaking up, locked herself in the bathroom and called the police. She later attempted suicide and was hospitalized in the ICU for a month. I wasn't informed. I later learned the court-appointed advisor and her father falsely told the hospital I was barred from contact, though no such order existed. A hospital worker, sensing something was wrong, risked her job to allow us to speak one time. That was my only contact for months. The entire time my daughter was in the hospital, I was not allowed any access to information. I wasn't allowed to speak to her. She wasn't allowed to speak to me. She would be crying. And she was given an angel to sit by her on that day that allowed us to at least speak one time. That was in the beginning of December 2021. I was granted a 2-hour visitation on Christmas Day, and then denied access again for 4.5 months. No speaking to my children, no seeing them whatsoever after I was the primary parent since birth. I filed motion after motion to enforce court-ordered parenting time, all when ignored by the judge, who issued this order as retaliation for me disclosing these abuses to the court. When I went to court for the initial emergency orders, we came in and they said, well, DCS and the police haven't done anything yet. They must not believe you. You better make sure the kids go to their other to the other parents' help. I pleaded, like, what do you want me to do? I cannot push them outside the door when they're crying and refusing to go. And he told me, ma'am, you better make them go or I'm going to take them from you 100% and put them with father. I pleaded, please don't do that. He said, well, then you better do as I say.
Who's the judge?
Judge Scott Blaney. I had a total of Judge Scott Blaney. He is now in the criminal court. He moved over from family court. However, I've had a total of 8 documented judges throughout my case during 2021 to 2024. So every time I would file a motion with the judge saying, like, he's not allowing me my parenting time, he just ignored them. The only reason my kids were taken is because, again, I went to the court. A police investigation opened up after our hearing where he told me they better make sure they go. At that point, Peoria Police ended up opening an investigation due to the doctor's office calling the police and reporting their concerns for sexual abuse. Because of that, my kids were taken home because I didn't see them. Finally, in April of 2022, I finally got into the court.
I'm sorry, Tia, can we go back just a second?
Yes.
This is your daughter's physician contacted law enforcement and reported suspected sexual abuse, I presume by the father.
Correct. Yeah.
Okay.
Yep, and
Just want to be clear on what you had said.
I apologize too, because I can be a little all over.
That's why I stopped you for just a second, so you could collect yourself and now.
So the police came to the doctor's office. They told me the kids cannot go to their fathers while this active investigation is ongoing. So now I was put into this position of, who do I abide by? The judge is telling me, you better make sure these kids go. And now I'm saying, if the kids go, DCS is going to take your kids from you. So what do you do? Obviously, I still didn't let them go. Finally, in April of 22, once I was able to see my kids, well, I got into court, I should say, they ordered me to supervise visitation. Again, just for reporting the abuse. There's no other allegation anywhere on me ever. So they ordered me to supervise visitation. They gave me 2 hours per week of parenting time and 2 30-minute phone calls a week, where I solely had to pay that expense for $1,000 a month, despite no findings against me. That lasted an entire year. There were nothing in place to review this. They do not review these records that they're ordering from the supervised parenting time agencies. You have to try to get them admitted during your hearing. So I had hundreds of reports with not one concern about me, and multiple disclosures documented by these parenting agencies that my children were continuously making disclosures of what was going on at their father's house. When I finally got rid of my attorney after paying, who even knows, over $50,000 probably within a 6-month period, I fired her, and I was immediately able to get myself off of supervised visitation. I was able to present the DCS guidelines for supervised parenting time, which stated this should be reassessed in 90 days. That never was done. At this time, and Judge Campanella was on my case. Let me just tell you, before that, there was also Commissioner Ash, who immediately recused herself. Then there was Commissioner Paula Williams, who tried to rule, at least in my favor, finding father in contempt, immediately taken off my case. Then Judge Campanella was put on my case. He took me off supervised parenting time, but did not change the hours. So I continued with only 2 hours of parenting time, all the way up until June of 2024. I kept fighting. I filed motions, emergencies, and even an appeal. All were denied. And I would like to say, I've been attending so many different meetings for years. I've been going to family court committees. There are so many of these same judges, including appeals judges, sitting on these family court committees, who then later, doesn't even make sense, sat in my family court case when he's an appeal judge. Don't understand how that happened. That is Judge David Gass. Again, nobody would change the orders from 2 hours a week. In April of 2024, I showed that father had been evicted. He was homeless and living with family members. He was leaving the kids unattended for several days at a time, making my daughter be responsible for them. In February of 2024, my daughter turned 18, and she had to make a very, very difficult decision to come home and leave, to protect herself and leave her brothers. So she had to leave them. When we went and got her stuff, it was documented on body cam footage, the significant amount of verbal abuse and just behavior that paternal family would display in front of the children. I went into family court. I showed again, like him destroying my daughter's bedroom, this body cam footage that shows how aggressive they were to not just my daughter, obviously to me, but in the presence of my children. Again, in April of 2024, they refused to act. Parenting time stayed exactly the same again. Then on June 1st, 2024, I picked up my kids for a scheduled visit. Minutes later, I received a phone call. It was private. Usually that means it's the police at this point. When I answered the phone, it was a detective from Peoria Police asking me if my children were with me. I confirmed they were, and then they conducted a raid on their father's house that he was staying at, where he was subsequently arrested for multiple sexual crimes against children, not of my own children either. DCS reported to my house that day and attempted to take the children from me. It was an 8-hour standoff.
Wait. Peoria PD verifies that your children are in a safe place before they conduct basically they execute a search, take him into custody on a warrant.
Yep.
then DCS contacts you to take your children from you?
Correct. So his family showed up at my house. I immediately contacted the police. The police reported to my house at first, trying to get them to leave, saying they didn't have any rights to my children. They would not leave. They escalated DCS.
I'm sorry, who said you didn't have rights?
No. They were telling his paternal family that showed up at my house. So he was arrested, and then his mother came, his sister came, both of his sisters came, his brother came, his sister-in-law came, and they would not leave.
So this is the father's family
Yes.
that does not have a court order for any kind of parenting time, obviously, shows up at your house in an attempt to try and take the children from you.
Correct, and they would not leave even with police instruction. So the detective then, they had escalated DCS to my house. And I should tell you, I've made numerous complaints to DCS. Doctors have contacted DCS multiple times. My children's medical doctors have testified in the family court disclosing that my daughter's disclosures were truthful, that they were not fabricated, and that she was not someone who was feigning or fabricating these disclosures. All of those were denied because they were not. She wasn't a court-appointed medical provider. So when DCS, I'm sorry.
We've got just a couple of minutes,
Okay.
so if you would, could you put a bow on this, all right?
So DCS came, they tried to take the kids from me. Eventually, Department of Child Welfare got involved. They escalated this all the way up to the Attorney General's office to say, no, the children can be staying with me. This happened on a Saturday. Monday, I went to family court, got temporary emergency orders. They put in those orders, and I got a police report as well that documented all of these evidence that was being presented against the father. They put on the order, I was given emergency temporary custody while father was incarcerated. Immediately after that, maybe about 2 weeks later, the county attorney, Erin Petticone, she subsequently dropped all of the sexual abuse charges despite the mountain of evidence, significant evidence that cannot be denied. And I apologize, I don't want to know the exact date, but I want to say June 15th of 2024, we then had another court hearing for the temporary orders. When we were walking, I went into the hearing, was waiting. Father got arrested on the way in for additional crimes against children, including aggravated assault against a child with a handgun. Temporary orders were affirmed again for the same thing. Because Department of Child Safety got involved and saw family court was not protecting the children, they have then escalated this all the way up to Attorney General in order to file a juvenile petition in order to protect my children. That was eventually thrown out. Said it has to be handled by family court because I'm a safe parent. And this is the same thing I've been told repeatedly throughout these things. So every time I would make a report, you're a safe parent. It is your job to go to the family court and fight for your kids. So then you go to family court and say, well, DCS didn't do anything. They know DCS doesn't do anything because there's one safe and protective parent. The police didn't do anything. Well, that's because 99% of all sexual abuse crimes are not prosecuted. Of course they didn't do anything. And so this is kind of just what's transpired. I have my kids. I'm one of the lucky few at this point. It is not because of my own fighting, despite how hard I fought. I have failed my kids because I could not protect them from the abuse. My daughter saved herself because she turned 18. My boys are lucky that they are with me. And it's only by the grace of God because He was able to make a way when there's no way. Nobody else would listen to me. Nobody else would listen to my kids. Nobody would talk to my kids from this court. I asked so many times for the judges, can you interview my kids? Can you order the court-appointed advisor to speak to my kids? Can you order the best interest attorney who is supposed to represent their best interest? Talk to my kids. Wouldn't even meet them. Never even met them. And so, please, I appreciate you so much for just trying to expose what is happening. I am not alone in this. There are so many parents who are experiencing the same thing, and most of all, children who are just suffering, and then they're going to grow up, and they are going to, I don't like to say this because it's not fair, however, it's very common that they are going to redo the things that they have experienced growing up, and somebody has got to protect them. Somebody has got to enact some sort of legislation that says, no, you don't have absolute power. You can't just be mad because you didn't do as the man said. It doesn't work that way. There has to be checks and balances. I have so much information I could provide you that it would be overwhelming. But I just appreciate you guys doing something, and thank you very much for this opportunity to speak. There was a lot more I wanted to address about some of these initial lady that came in about the judge's performance complaints. Last year, in May of 2024, the Superior Court actually held a law day where pretty much no members of the public attended besides me and my friend. They thought they were just in a room amongst their peers. And they're telling us, they aren't investigating family court complaints because just like you said, one party's always unhappy. They don't even investigate them. And if they do, and they found there's misconduct, they allow them the opportunity to retire versus facing any sort of repercussion. And I have that on recording as well, if you would like that.
Thank you for your testimony, too.
Thank you very much.
This will not go unnoticed. And that's, your closing comment is exactly why I asked folks, please, let's limit this to personal experience, the court, and not the ex-spouse. I gave you quite a bit of latitude because I think the circumstances dictated it.
Correct.
Members, do you have any questions for Tia? All right. Thank you very much for coming. All right, ladies and gentlemen, we are at 12 o'clock noon. We're going to recess this committee until the sound of the gavel at 1 o'clock.